Good morning. I'm Dwight Keene. I'm chair of the Kansas Corporation Commission. I'm joined this morning by fellow commissioners Susan Duffy and Commissioner Andrew French. At this time, I'm convening the hearing in the matter of the application of the Empire District Electric Company for commission approval to make certain changes in its charges for electric service via docket number 21-EPDE-444-RTS. Due to the pandemic and for the convenience of the parties in the commission, we are conducting this hearing by Zoom and broadcasting to the public on YouTube. Please bear with us if you experience any technical glitches. This morning, we will first turn to the entries of appearance, and I will first turn to Empire.
Good morning, Your Honor. James G. Flaherty, Ottawa, Kansas, appearing on behalf of the applicant, the Empire District Electric Company.
Good morning, Jim. Citizens Utility Ratepayer Board.
Yes, Commissioner, this is Todd Love, attorney with CURB, appearing on behalf of CURB. Also appearing or entering their appearances are David Nickel and Joseph Astrab. I will let the commission know I plan on doing the hearing in full, so you probably won't hear much from them.
All right, thank you, Todd. The KCC staff.
Good morning. Carly Massentine and Jared Jevons to be appearing on behalf of commission staff and the public generally.
Good morning, Carly. At this time, does the staff have any recommendation regarding notice?
Yes. Staff has examined notice and reports that on July 13th, 2021, the commission issued its order adopting procedural schedule and designating presiding officer, which set the hearing to begin on today's date, March 8th, 2022 at 9 a.m. and continue through March 10th, 2022. The hearing dates were reaffirmed in the commission's order granting motion for modification of the procedural schedule and designating a new presiding officer, which was issued on January 13th, 2022. And the hearing dates were once again reaffirmed in the commission's order modifying procedural schedule issued March 3rd, 2022. The certificate of service for each commission order included the address on file for all parties, and subsequently there was communication between the parties in anticipation of this hearing. Staff notes the parties appeared today in person and therefore recommends a finding that notice was proper and that the commission has jurisdiction to hear this matter at this time and place.
Thank you. Are there any objections to notice? Hearing none, I find that notice is proper and that the commission has jurisdiction over this proceeding at this time and place. Before we turn to preliminary matters, let's briefly consider a few matters incidental to conducting a hearing via Zoom. First, if any party encounters any technical issue today, I would encourage you to ask to go off the record so that we may resolve the technical issue off the record. Second, witnesses participating by Zoom are requested to keep their microphones off when they are not scheduled to speak. Third, if the commission needs to deliberate, we will be going off the record, entering a Zoom breakout room where you can't see us or hear us, and subsequently returning. And fourth, since we are participating at a distance across the expanse of basically eastern Kansas, please be careful to identify exactly what you are referring to when discussing pre-filed testimony and exhibits. We have copies of all of that on hand, so we should be able to follow along if you will assist us in identifying it. I understand that Empire wishes to admit pre-filed testimony into the record and may also be asking for the commission to take administrative notice of certain items. Mr. Flaherty.
Yes, thank you, Your Honor. I actually have three preliminary matters. The first one, like you said, is to move for the admission of the direct and rebuttal testimony of Frank Graves, since his testimony only related to the settled issues. The second motion is...
Before you proceed, let's go ahead and handle these in turn if you don't object.
Sure, that'll be fine.
Is there any objection to the admission of the pre-filed testimony as described by Mr. Flaherty? Hearing none, they are admitted. Please continue, Jim.
Thank you, Your Honor. The second is to request that the commission take administrative notice under its regulations of its files and records of 4 documents in docket number 18-WSEE-328-1 RTS, which is the case involving the Western Plains wind farm. Those testimonies and commission order are the direct testimony of Justin Grady, filed on June 11th, 2018. The direct testimony of Dr. Glass, filed on June 13th, 2018. The testimony filed by Mr. Grady in support of the settlement, filed on July 18th, 2018, and the order approving the settlement in that case, which was issued on September 27th, 2018.
Is there any objection?
Yes, Chair Keen. Staff objects to taking administrative notice of both Dr. Glass and Justin Grady's direct testimony in the 18-28 docket. We do not have an issue with taking administrative notice of the order for Justin Grady's settlement testimony in that docket, but the direct testimony of both Mr. Grady and Dr. Glass was filed prior to a settlement agreement that was reached among the parties. And necessarily to reach that agreement, both parties had to move away from some of the positions taken in their direct testimony. So we question the relevance of both of those documents, the direct testimonies.
Mr. Flaherty?
Yes, thank you, Your Honor. So commission staff in its testimony in this case, as part of trying to determine the value of Empire 3 wind farms, discusses the Western Plains wind farm in that case that I cited. In that discussion, in their testimony, they basically try to indicate that the Western Plains wind farm and the fixed price PPA price that was set for that wind farm in that case is somehow could be used by the commission to make a decision in this case. Therefore, the testimony of Mr. Grady and Dr. Glass, who discuss how the staff valued that wind farm, is relevant in this case. And the commission can take administrative notice of its files and records. Can also give it the weight that it's worth, but we feel like it is entirely relevant to the issues in this case, and we'd renew our motion for the commission to take administrative notice of that. And it appeared they didn't have any objection to the order.
Ms. Maslin?
Yes, to respond to that, I would also like to point out that Dr. Glass is not here today to speak to any of the substance of that testimony they're requesting. As far as Justin Grady's testimony goes, I still would object to the entrance of his direct testimony for the reasons I stated previously. However, Justin will be at this hearing either today or tomorrow, and we would offer that if Empire wants to enter that testimony at that time, they can lay the foundation to do so. But we would still object to administrative notice of both of those direct testimonies.
Ms. Maslin, I have a question for you. If we were to uphold the staff objection, how would the staff suggest that the commission circumnavigate the Kansas Administrative Procedures Act, specifically KSA 77-524F, which provides in pertinent part, and I quote, official notice may be taken of, number 2, the record of other proceedings before the state agency, unquote.
Chair Keen, again, I would say that this is a relevance argument. We don't believe that the direct testimony of Justin Grady or Bob Glass is directly relevant. We do understand that the order in that docket and Justin Grady's settlement testimony would be relevant. And additionally, although I can't remember off the top of my head, I do believe that Bob Glass had filed settlement testimony in that docket as well, which we would not object to the admission of.
All right, thank you. Mr. Flaherty, any further observations before I rule on the motion?
No, Your Honor.
Okay. I'm going to overrule the KCC staff objection. I'm going to allow the commission to take administrative notice of the items requested by Mr. Flaherty. In doing so, I will note that the commission may assign whatever weight it ultimately deems necessary with respect to the noticed items. I would also note that, as Ms. Maslin had indicated, Mr. Grady is scheduled to be a witness in these proceedings, and as such is going to be subject to direct and cross-examination on all matters relevant and pertinent to these proceedings, potentially including the noticed items. Accordingly, I will overrule the motion and admit, or we will take administrative notice of the items requested by Mr. Flaherty.
Thank you, Your Honor. The third item I have as preliminary matter is that if you notice that the settlement, the partial settlement that was filed in this case had one item that was marked confidential. After discussing that with Empire, we can release the confidential designation of that one. And I think it was just an LCOE price that was in both the motion and the settlement. And I've got the site for that. It's in the motion, it's page 3, paragraph 5. And the LCOE price that was redacted that now can be made public is $23.97 per megawatt hour. And then in the settlement, that same number is on page 3, paragraph 5 of the settlement. And that redacted number can be made public. It's $23.97. We will file in the docket room a new version so that the entire partial settlement agreement then is public.
Very well. Is there any objection? Without objection, request is granted. Are there any other preliminary matters any parties wish to address at this time?
Yes, Chair Keen, staff has one preliminary matter it would like to address. We will be shortly sending out a PDF file that contains the source material for the sources and footnotes in Nick Puga and Colin Kane's direct testimony. We believe that these are already a part of the record, and so that they have been included, the sources have been included as footnotes in that testimony. However, for ease of reference and similar to what was done in the transportation electrification docket, we have elected to provide these sources in a PDF file for everyone to view, so they don't have to go and dig through the footnotes to find those.
Very well, thank you for noting that.
And I do have one more preliminary matter, Chair. I would like to move for the admission of Brad Hutton's direct testimony into the record.
Very well. Is there any objection? Without objection, it's approved. It's admitted. All right. Regarding procedure for this hearing, the procedures are set forth in the pre-hearing officer order setting the format for the evidentiary hearing. As the parties have agreed, we will begin with Empire's opening statement, followed by that of CURB, and then the KCC staff. After opening statements, we will follow the order of witnesses agreed to at the pre-hearing conference. Likewise, the parties have agreed to the order of cross-examination. I understand that at the pre-hearing conference, the parties indicated that they will not make closing statements. However, we will follow a procedural schedule that allows for post-hearing briefs. This hearing will address both the issues agreed to in the unanimous partial settlement, as well as unresolved issues relating to the wind projects. Due to the witness availability and the order of witnesses, we may occasionally switch from one topic to the other as the need arises. Let's turn now to opening statements, and we will begin with Empire. Mr. Flaherty, please.
Thank you, Your Honor. And if we can go ahead and put up the PowerPoint presentation, and I provided that to Mr. Cohen, so hopefully he was able to get you copies of this PowerPoint presentation.
All right.
And we'll put it up on the screen here. There we go. Good morning. Empire appreciates the opportunity to present its case to the commission. If you turn to slide 2, please. The main question that needs to be decided by the commission in this case is whether Empire should be allowed to recover its Kansas allocated portion of its actual capital cost and its actual O&M costs relating to its 3 new wind farms. Let me explain why Empire should be allowed to do so. Slide 3, please. Before I point you to a few foundation and uncontested facts in this case, it's important to point out that Empire uses its actual capital cost and its actual O&M costs to support its rate request. After all, that is how this commission sets rates. Kane and Puga, on the other hand, are using offers, not even real prices, for unknown wind farms that could have been pulled off the internet without any evaluation as to whether those wind farms are comparable to Empire's wind farms, which they are not, to determine the cost of the wind farms. Kane and Puga don't even take into account the revenue side of the necessary valuation, likely because their internet information did not include or discuss revenues. Empire's rate case is reasonable given the amount of revenue that the wind farms will generate and the savings that will be provided to our customers. In addition, on top of those savings, there are important benefits with Empire owning and operating these wind farms instead of having to rely upon an unregulated third party for energy for its customers over the next 20 to 30 years. Slide 4, please. Here are the foundational and uncontested facts in this case. First, none of the parties disagree that it is going to cost Empire on a levelized cost of energy or LCOE basis, levelized over 20 years, $33.73 a megawatt hour to provide the capacity and energy to its Kansas customers from its 3 new wind farms. On this first point, it is important again to point out that the KCC uses the utility's actual capital cost and actual O&M costs to determine what should go into rates. Empire's provided that information in its rate filing, and its $33.73 per megawatt hour number is based on that actual cost information using a 20-year fixed price PPA rate making option should the commission wish to equally levelize the benefits over that 20 years like it did in the Western Plains case. While staff argues Empire should have entered into a PPA instead of owning and operating the 3 wind farms, it did not really contest that these aren't Empire's actual capital cost, or these aren't Empire's actual O&M costs to own and operate these wind farms for the benefit of its Kansas customers. On the revenue side, staff only made a small adjustment to the revenues. I think it was $90,000 out of $2.7 million that Empire indicated its wind farms will generate for the benefit of its Kansas customers. Second, none of the parties disagree that before Empire acquired its 3 new wind farms, it conducted an IRP study looking at various generation options under more than 50 different scenarios relating to things like the cost of natural gas and energy prices in the SPP market. And based upon that, determined that a combination of retiring Empire's Asbury coal plant and obtaining wind would result in the most savings to customers. That extensive analysis is laid out and explained by Mr. McMahon in his direct testimony. Staff challenged the amount of projected savings shown in that IRP study because they believed the study's future cost of gas was too high, or the future cost of energy in the SPP market was too high. But those numbers actually look low now compared to what is going on currently in the market. But it did not challenge the fact that Empire conducted and relied upon that IRP study, or that IRP study was reviewed and approved by the Missouri Public Service Commission. It's also important to point out that neither staff nor CURB did their own study. Third, none of the parties disagree that before Empire acquired its 3 new wind farms, it hired Burns & McDonnell to assist it in developing a request for proposal or RFP process to solicit bids from wind developers, and that it received and evaluated bids from 20 different wind projects, and based upon that evaluation, selected its 3 new wind farms. That RFP analysis is laid out and explained by Sean Rooney's direct testimony and exhibits. He provides a copy of the RFP that was developed by Burns & McDonnell. He provides the list of wind developers that submitted bids, all who are reputable and well-known. He provides a matrix showing the evaluation that Empire and Burns & McDonnell performed in order to select the best wind projects. None of the parties has questioned that evaluation process or challenged that based upon that evaluation process, that Empire selected the 3 wind projects out of the 20 wind projects evaluated that best met the criteria that was reviewed. Slide 5, please. Where the parties do disagree really centers on two items. The parties disagree on whether Kansas customers need the capacity and energy from these 3 new wind farms, and the parties disagree on Empire's decision to acquire, own, and have direct control over the operation of these 3 wind farms. Slide 6, please. There are 5 main reasons why it was prudent for Empire to own and operate and have direct control over these 3 wind farms. Reason 1, reliability and obligation. And I like to refer to this reason as this is what we do reason. For over 100 years, Empire has owned and operated generation to supply to its customers. You know, when the customer flips the light switch at home in Galena or needs to keep their freezers at their convenience store in Baxter Springs on Route 66 cold, they can rely upon Empire having the electricity for them because in part, Empire has direct control over the generation that provides that electricity. Having direct ownership and control over operations of a generator like the 3 new wind farms is important for Empire to meet its obligation to provide reliable electric service to its customers. Storm Uri is a good example as to why it is important for a utility like Empire to own and control operation of its generation instead of the utility having to rely upon an unregulated third party during those critical periods. Sure, that unregulated third party has a contractual obligation to Empire, but we can all see how that didn't work out that well for utilities and their customers in Texas during Storm Uri. That contractual obligation is nothing like the statutory and regulatory obligation that Empire has to its customers to provide reliable service, you know, especially when not meeting that obligation could result in the loss of life or substantial property damage to homes and businesses because pipes freeze and break. In the example of Storm Uri, the wind farms were where Empire currently has PPAs in place to purchase the wind energy. Those wind farms were frozen and unable to produce energy. A utility-owned plant knows that it needs to exhaust every avenue to keep the plant generating during an extreme event, and if not, prudence could be called into question. Operating these wind farms may be a bit different than operating the generation facilities that Empire has operated at Riverton, Kansas for the last 100 years, but there are also a lot of similarities. Empire can keep doing what it does by owning and operating these wind farms. It can't do what it does best if it is relying upon an unregulated third party to operate the generation that Empire has to rely upon to meet its obligation to its customers for the next 30 years. Let me just give you one quick example of where Empire's ownership has already made a difference. Empire had the presence of mind to require that all 3 of its wind farms install the cold weather package so that the wind farms can operate in challenging conditions like Storm Uri. Many unregulated developers did not make that same choice. This commission staff commented on that point in its recent review of Evergy's Storm Uri docket. And this is a good example of how Empire, by owning and having direct control over these wind farms, protects customers and reliability of service. Reason 2, the next reason for owning and operating the wind farms is what I like to refer to as with ownership comes some additional benefits for customers. By owning and operating the wind farm instead of having an unregulated third party own and operate the wind farms, Empire and its customers can receive additional benefits. Control over the ability to make improvements to wind projects in the event of new technology, control over the wind projects to improve capacity. And this next one's important, control over the generator interconnections so it has the ability to upgrade it in the future. Ownership of a generator interconnection has a huge value in today's electric market. There are big discussions about that value at SPP and other RTOs, and a big part of a utility's IRP planning process because a utility can add batteries or coal solar generation with the wind farms and use the existing generation interconnections because it owns the wind farms. Empire does not have ownership of the generator interconnection if it only has a PPA and loses all of those future benefits. Empire's current IRP that is being developed is taking into consideration the fact that Empire has control over the generator interconnections at its 3 wind farms. If Empire does not own those, because it does not own the wind farm and only because it has a PPA for the wind energy, Empire is at more risk of having to wait for SPP longer for a new interconnection or for new generation. As the industry pivots to renewables, there are discussions around the nation, and in particular SPP, regarding what's referred to as resource adequacy and accreditation. The recent focus of the SPP to improve resource assurance, and this commission knows this because Kansas is taking a very active position in the SPP Improved Resource Availability Task Force, will almost certainly lead to the performance-based accreditation discussed in Mr. McMahon's rebuttal testimony. Combine the likely decrementing of thermal capacity with the possibility of long GI queues, Empire having the flexibility of co-locating resources at existing GIs will be of tremendous value for entities trying to stay above the resource adequate threshold. No such option would exist under a PPA because Empire would not own the GIs associated with those wind farms. There's also extreme value with having ownership of these existing GIs relating to these new wind farms because of how close they are located to Empire's distribution system. Reason 3, the next reason why Empire came to the determination it did on ownership is what I like to refer to as the tail wagging the dog reason. While I will be the first one to defend this commission's right to determine what is best for Empire's Kansas customers in Southeast Kansas, there has to be at least some reasonable acknowledgement that 90% of Empire's electric operations are in Missouri, and some reasonable acknowledgement that those operations are regulated responsibly by the Missouri Public Service Commission. After all, Empire only has about 4.5% of its operations in Kansas. Thus, Kansas is the tail wagging Missouri the dog. This is a reason as to why Empire elected to own the 3 wind farms. The Missouri Commission reviewed Empire's IRP and its generation fleet savings analysis, or what's referred in this case as the GFSA, and Empire's request for certificates of convenience and necessity for the wind farms. And the Missouri Public Service Commission determined that it would be in the best interest of Empire's Missouri customers for Empire to own and operate the 3 new wind farms. Empire certainly acknowledges that the Kansas Commission is in no way required to follow the decision made by the Missouri Commission, and that reasonable commissions can reach different decisions. But from Empire's perspective, the fact that it received the Missouri Commission's approval of ownership and operation of these wind farms was a good reason as to why Empire does in fact own and operate the wind farms. Reason 4, diversification of renewable energy portfolio. Empire already has 255 megawatts of wind energy that it purchases under PPA contracts, where those 2 Kansas wind farms are owned and operated by someone other than Empire, and where Empire must rely upon that unregulated third party to provide it the wind energy from those 2 farms. By acquiring, owning, and operating the 3 new wind farms, Empire was able to diversify its renewable energy portfolio by having some wind energy under a PPA arrangement and some wind energy under an ownership arrangement. The evidence in this case will show that Evergy, the other and the only other investor-owned utility in Kansas, has a diversified renewable energy portfolio where it owns and operates 5 wind farms and purchases energy from other wind farms under a PPA arrangement. That is in Mr. McMahon's rebuttal testimony. Also, one last point on this matter, the evidence is going to show that the trend in the United States is an increase in the utilities owning and operating their own wind farms. Prior to 2020, utilities owned and operated about 16% of the total wind capacity in the United States. In 2020 alone, 27% of the wind capacity that came online in the United States was owned and operated by utilities. That evidence will be discussed with Mr. Crane and Mr. Puga. Finally, reason 5. The next reason why Empire determined that ownership was best was that Empire had the ability to capture all the advantages of using a tax equity partnership to finance its acquisition of the wind farms that it would have received under a PPA approach. Because of Empire's parent company's expertise in the development of wind projects, Empire was able to take advantage of that expertise to use a tax equity partner to assist in financing its acquisition of the wind farms at a 40% savings to Empire's customers. Mr. Mooney discusses that in his testimony. Staff points out that such an arrangement is used by unregulated companies to finance their wind farms, and that those advantages would show up in a PPA price to Empire. But I would suggest that Empire misses the point. It's not that the unregulated company can provide some or all of that benefit in the PPA price. The point is that Empire, as a regulated utility and one of the first in the country to do so on a wind project, was able to internalize the benefits of tax equity financing for its customers and did not need to rely upon an unregulated company in order to obtain the tax equity benefits through a PPA. This reason segues into the main reason why we're here today and why Empire staff and CURB could not reach agreement on the fair value of these wind projects. Contrary to staff's position, it was not necessary for Empire to obtain bids for a PPA approach to then compare it to an ownership operation approach, because based upon the 4 criteria used by Empire and Burns & McDonnell to evaluate the bids that Empire received on 20 proposed wind projects, and the way in which Empire itself was planning on taking advantage of using tax equity to finance the acquisition of the wind projects, there would have been little, if any, difference between the LCOE price for the wind projects that were being evaluated under a PPA transaction or what they referred to as a build-own or BOT transaction. Let's think about it this way, and let's use Empire's Neosho Ridge wind farm, which is located in southeast Kansas, which is one of these 3 new wind farms as an example. Empire acquired that Neosho Ridge wind farm from Apex. Apex is a developer of the wind farm. If instead Empire would have done a PPA with Apex, Apex would have had the same operating costs as Empire likely would have had with the plant. Since they were both using tax equity, the cost of capital would be about the same, and the tax credits and the accelerated depreciation benefits and how they are used would be about the same. The additional value that location of the wind farm, with it being close to a high price node and close to a load node, namely Empire's load, would have been captured in both the PPA price and the BOT price analysis. So with no difference in the price or value between a PPA and a BOT, then using a PPA approach did not have a price advantage over BOT. And so for all the other reasons that I just went through, Empire decided to acquire, own, and operate the 3 new wind farms. Slide 7, please. This slide just provides a recap of how Empire determined its actual capital cost, its actual operating cost for the 3 wind farms, and how that was reasonable, and how that whole process of how it selected the best 3 wind farms was reasonable. Let me highlight one additional point on this slide 7, and that's at the bottom, item number 6. And it may get missed in this case, but it adds value to Empire's 3 wind farms, and that is the ability of Empire to be able to repurpose part of the retired Asbury coal plant to run the 3 wind farms. Empire would not have been able to do that under a PPA for a wind farm in western Kansas or western Oklahoma or North Dakota. By selecting wind farms near and in Empire service territory, Empire was not only able to repurpose part of its retired coal plant to save costs for its customers, it was also able to give those employees that had spent their entire lives working at that Asbury coal plant the ability to keep working and stay close at home. Slide 8, please. Now, in contrast, let's look at what Mr. Crane and Mr. Puga did to come up with their value of $16.32 a megawatt hour for Empire's 3 wind farms, a number which is not based upon actual cost, which again is what Empire and the commission used to set rates. Crane and Puga did three things. The three things they did are listed on this slide 8, and frankly are things that you or I could have done using a Google search and typing in, show me the PPA prices for wind energy in the SPP market area. Slide 9, please. The first thing that Mr. Crane and Puga did was looked at PPA offers, and let me stress that those were not PPA prices, just PPA offers reported by what is referred to as level 10. Level 10 publishes the lowest 25% of the initial offers for PPA wind, and Mr. Crane and Mr. Puga used those reported offers to support their $16.32 number. Like other things of value, where a wind farm is located could have a huge impact on its value. What makes a wind farm more valuable than another wind farm is whether the wind farm's generation interconnection is in the SPP area, where the locational marginal pricing or LMP price nodes have higher prices than SPP areas where the LMP price nodes have lower prices. What's important in this case to understand is that revenues generated by the energy from these wind farms is important as to the value that wind farms provide to customers. So the higher price node, the more revenue, the more value to customers, makes the value of the wind farm greater. And on this point, it's important to make that if you look at Mr. Crane and Mr. Puga's analysis of valuing Empire's 3 wind farms, they only refer to the PPA initial offer for a wind farm. They leave out the revenues generated by the wind farm in their determination of the value of that wind farm. Crane and Puga leave off half, and perhaps the most important half, of the evaluation. For example, a wind farm that generates $20 million in revenue each year has a greater value than a wind farm that only generates $5 million a year, because the higher revenue producing wind farm is located in a high price node area in SPP compared to the other wind farm that is located in lower price node area. As we will show you the information maintained by SPP, and perhaps you've looked at that information before at the SPP website. SPP maintains what are referred to as heat maps. And Mr. McMahon has one of these most recent SPP heat maps in his rebuttal testimony, and I will put it up on the screen. Amy, can you turn to slide 12 for just a second? So here's the heat map in Mr. McMahon's rebuttal testimony. Those SPP heat maps show that Empire's 3 wind farms are located in a very high price node areas. And if you recall, higher price nodes produce higher revenues, and higher revenues make Empire's wind farms more valuable than a wind farm in an SPP low price node area like the Western Plains wind farm referred to by Crane and Puga. Amy, if you could go back to slide 9. Thank you. Let me bring this all back to the level 10 information that Crane and Puga looked up on Google. First, none of the level 10 information tells us where the wind farms that the developers are making PPA initial offers are located in SPP. They could be for future farms in Western Oklahoma, Western Kansas, far away from Empire's node, located in a low price node and not a high price node area, in an area where there's a lot of transmission congestion and transmission risk. Also, as I indicated, the level 10 information only provides the 25% lowest PPA initial offers. Ask yourself which wind farms have the lowest PPA offers. Perhaps the wind farms that are located in a low price node area where expected revenues will be low, or in areas that are far away from load nodes, so the transmission risks are high relating to those wind farms, which is just the opposite of Empire's wind farms. So you can start to see perhaps why Mr. Crane and Mr. Puga's value is different than Empire's value for Empire's wind farms, and why Crane and Puga's PPA initial offers are not relevant in attempting to determine the value of Empire's wind farms. Slide 10, please. There are some other problems with the level 10 Google information, and let me just mention those quickly. The offers usually do not include transmission costs. The offers are on average are far shorter period of time, like 14 years instead of 20 years. The offers, like I said, are the lowest 25% offers. So level 10 provides no information on what the average offer was for an average PPA or an average wind farm, or the 75% of offers, which may have picked up wind farms like Empire's wind farms that are located in high price node areas and close to load nodes and have greater value than those wind farms that are in low price node areas and far away from load nodes. What else don't we know about these PPA offers pulled from the internet? Do these PPA offers contain take or pay requirements, which increases and increases the cost to customers? Do they have provisions where the price escalates over the term of the agreement? Slide 11, please. Going back to Storm Uri, do the proposed wind farms have cold winter packages? Empire's wind farms have cold winter packages that allow those turbines to operate at temperatures down to negative 22 degrees Fahrenheit. Kane and Puga's valuation of Empire's wind farms do not take that into account. Slide 13, please. One other point on this before I move on to the two other sources used by Kane and Puga to determine the value of Empire's wind farms, and you can ask Kane and Puga when they take the stand. In attempting to determine what an applicable PPA price would be for Empire's wind farms, we asked Kane and Puga, how many actual PPA contracts did you review during your analysis to determine what a reasonable PPA price would be for Empire's wind farms? Real PPA contracts that would show the location of the PPA wind farm, would show whether it was like Empire's wind farms located near high price SPP nodes and close to load nodes, would show what the term of the PPA was, would show the final PPA price instead of just an initial offer to get a buyer into the door, would show if the PPA price included a price escalator or a take or pay requirement, or that would show the anticipated capacity. The response that we received from Kane and Puga was that they looked at 0 actual PPA contracts in making their evaluation. Slide 14, please. The second reference that Kane and Puga used to determine support for their $16.32 value of Empire's wind farms was a report that also immediately shows up on a Google search asking to show PPA prices in the SPP market. We will introduce that report as an exhibit because it has some relevant and interesting information that could be of some value to the commission in this case, like what the trends are for utilities to own and operate wind farms. The one thing the report doesn't have is relevant information that can be used to determine the value of Empire's 3 wind farms. The report does indicate that in the central region of the country and in SPP that recent PPA pricing is around or below $20 a megawatt hour. But that $20 a megawatt hour PPA price from the report that Kane and Puga rely upon has the same fatal flaws as the level 10 offers they rely upon. The report does not provide the range of PPA prices for wind farms in SPP. For example, it doesn't provide a comparison of PPA prices for wind farms that are located in SPP high price node areas that can generate high revenues versus wind farms that are in SPP low price node areas that generate low revenues. The report simply doesn't provide reasonable market comparables or comps to determine the value of Empire's wind farms because critical information is not included in the report. Kane and Puga would have you believe that all of these wind farms in the SPP have the same PPA price and value. That's simply not the case, and common sense tells you, and you don't have to be an expert on the SPP market to make that determination. Slide 15, please. The final item that Kane and Puga relied upon was a review of the KCC order in the 2018 Westar Energy rate case, where the commission approved a settlement that contained a fixed price purchase agreement for Westar's Western Plains wind farm located near Dodge City, Kansas. The commission agreed to an LCO fixed price of $20.70 a megawatt hour for the Western Plains wind farm. Kane and Puga suggests, therefore, that the LCOE price for Empire's wind farms should not be any higher than that $20 number approved for the Western Plains wind farm. However, a comparison between the Western Plains wind farm and Empire's 3 new wind farms provides the best evidence that clearly shows the fatal flaws in Kane and Puga's valuation process. The location of the Western Plains Farm, like I said, is near Dodge City, Kansas, and is in walking distance of 10 other wind farms. Western Plains Wind Farm is located in a low price node area of SPP and provides significantly lower revenues than Empire's 3 wind farms. As will be shown in Mr. McMahon's rebuttal testimony, the price for energy from Western Plains Farm is between $10 to $16 per megawatt, less than the price for energy from Empire's 3 wind farms. The Western Plains Wind Farm produces significantly less revenues than Empire's 3 wind farms and therefore is less valuable. Western Plains is also in a location that is far away from Evergy's load node in an area where with high transmission risk of the utility being able to even get the energy from the wind farm to its load node. Empire's 3 wind farms, on the other hand, are in a location that is near or in Empire service territory and load node. If you just boil all this down and you just want to take into account the $10 to $16 a megawatt difference between the energy prices of the 2 wind farms, that shows why Empire's wind farms have a value of $13 a megawatt higher than Western Plains. Kane and Puga don't take into account the difference in revenues generated by the energy from the 2 wind farms in their evaluation. And just like their reliance on the level 10 offers and DOE report numbers, their valuation process assumes that all wind farms have the same value and can earn the same PPA prices. Again, common sense should tell you that's simply not the case. Finally, I'd be amiss if I didn't mention CURB's recommended LCOE number. Let me just say that if the LCO number being recommended by CURB, and which comes from the GFSA study, when Empire was attempting to compare Asbury to potential wind farms, is adjusted so it is calculated in the same way the Puga and Kane number and Empire have calculated their LCOE numbers. And Mr. McMahon discusses this in his rebuttal testimony. The apple-to-apple LCOE number for CURB would be in the $30 per megawatt range. Slide 16, please. All of Empire's witnesses are knowledgeable about these matters that I've laid out in this opening statement, and they'll be happy to answer your questions that you might have. As I indicated at the beginning of my opening statement, it is Empire's position that Kansas customers will benefit from the capacity and energy from these 3 wind projects. If the wind projects are disallowed, our Kansas customers' costs will increase when Empire has to replace the required generation. Empire acted prudently in deciding to acquire and own these wind farms instead of having to rely upon an unregulated third party for energy under a PPA for the next 30 years. Empire used a reasonable and extensive RFP process to obtain bids on 20 different projects. It evaluated each project using specific criteria to determine which project made the most sense for Empire. And based upon that analysis, it came up with the 3 wind projects. The $33 number is what it actually costs Empire to own and operate these wind farms. And at that price, given the revenues that will be generated and the fuel cost avoided by not having to use other generation, will provide significant benefits for Kansas customers. The Google valuation conducted by Kane and Puga was critically flawed and not credible for the reasons outlined in Empire's testimony and the evidence that you're going to hear today from all the witnesses during this hearing. I know I didn't spend any time on mentioning the settlement of the other issues, and I believe staff and CURB will discuss that in their opening statements, but Mr. Tillman, who was directly involved in the settlement of the other 2 issues in this abbreviated rate case, will be testifying on the terms of settlement. He can answer any questions that you have regarding those terms. After hearing the evidence and having your questions answered, Empire would request that the commission accept Empire's actual costs to own and operate these 3 wind farms and include those costs in Empire's revenue requirement and the revenues in the ECA. In the alternative, to use the $33.73 megawatt hour as a price to include in a fixed price PPA like was done in the Western Plains case. It would ask that the commission also reject the valuations conducted by Kane and Puga for the reasons I've just discussed. Thank you.
Thank you, Mr. Flaherty. Could we take down the screen sharing? Perfect. Somebody's anticipating me. Very good. All right. Next opening statement will be for CURB, Mr. Love.
Yes, Commissioner, as a preliminary matter, I was just going to ask Mr. Flaherty, was a copy of the presentation he just sent or just provided, the PowerPoint sent out to the parties? If it was, I never received one.
Yeah, Todd, did you also get the exhibits that we pre-marked?
I don't, I got the testimony of Justin Grady, et cetera. I think there were four total things, but I didn't see, maybe I just missed it. I didn't see a copy of the PowerPoint.
Okay, yeah, that came with the exhibits that we've pre-marked as exhibits that we may use in this case. And those were sent to everybody that was on Mr. Cohen's email when he sent out the script for the hearing. This morning, it would have been about, around 8 o'clock, 8:15, something like that.
Double check. I just didn't see it. I may have just missed it as I went through my emails this morning.
While you're talking, I'll send it to you again.
Okay, thank you very much.
I haven't saw any of that either. So if you want to just resend it to everybody.
Oh, you don't have that? Okay.
No.
Oh, maybe it bounced back. Okay.
Okay, I don't feel so foolish now. So
Okay.
thank you.
Thank you.
Yes.
Commissioner, if you're ready, Commissioner, Curb is ready to proceed.
Just one matter, and we will be ready for you. Yes, I would appreciate it, Jim, if you could recirculate that to all. I don't think the commission's seen it. I hadn't seen it either. And I think it would be beneficial if you could recirculate, please. All right, Mr. Love, please.
Thank you. Yeah, no, pardon me for interrupting. So, good morning, Commissioners. As you know, my name is Todd Love, and I'm an attorney with the Citizens Utility Ratepayer Board, affectionately known as CURB by pretty much everybody. We're here today to try this docket regarding Empire's abbreviated rate case application. On February 5th, 2020, Empire filed the motion with the KCC requesting authorization to file an abbreviated rate case to address three issues. One was the retirement of the Asbury coal plant and the resulting revenue required impact. Two, capital and operating costs associated with the acquisition of 3 wind projects. 3, non-growth plant additions and related accumulated depreciation and deferred income taxes for the test year ending June 30th, 2020. As noted by Mr. Flaherty, 2 of these 3 issues have been resolved by unanimous settlement. I am not planning on going into the details of the unanimous settlement. Our witness, Andrea Crane, has filed her testimony in support of the partial unanimous settlement agreement, as have the other parties, I believe all filed yesterday afternoon, if I recall. Reiterate her testimony here, but CURB does believe her testimony shows that the partial settlement meets the 3 criteria used by the Commission. Namely, it is supported by substantial competent evidence in the record as a whole. It will establish just and reasonable rates, and it is in the public interest. That leaves us with the main issue we're dealing with here today, the issues regarding the capital and operating costs associated with the acquisition of 3 wind projects. On June 23rd, 2020, the Commission approved Empire's request to file this abbreviated rate case. Empire filed the application on May 27th, 2021. In its application, the company requested a base revenue increase of $4,465,955. This application included the following: capital and operating costs associated with 3 new wind projects. These include the Neosho Ridge Wind Project, the North Fork Ridge Wind Project, and the Kings Point Wind Project. The Neosho Ridge Wind Project is located in southeastern Kansas, and the other 2 wind projects are located in southwestern Missouri. I believe that was noted by Mr. Flaherty in his opening statements. The company proposed 2 alternative rate-making treatments for those costs, either recovery and rate base through the traditional rate case process, or recovery of the revenue requirement over 20 years on a fixed levelized cost of energy basis. In both cases, the company proposed, in both cases, the company proposed that associated wind revenues would be credited to customers through the energy cost adjustment riders. As mentioned earlier, in Empire's initial application, they proposed a base revenue increase of $4,465,956, or approximately an increase of 26.4%. Empire anticipates the net revenues from the new wind projects would result in incremental revenue of $2,817,422, which are proposed to flow through the energy cost adjustment mechanism. In addition, the company proposed to refund $2,774,857 to ratepayers over a 3-year period, or $924,952 annually, reflecting amounts associated with Asbury and collected from ratepayers between the retirement date of Asbury and the effective date of the new rates in this case. Therefore, Empire initially and originally proposed a net increase of $723,581, or 4.28% increase, which equaled the amount of $4.97 monthly increase to a residential customer. That would be a 4.47% increase. On September 15th, 2021, Empire updated its filing to reflect updated costs for the wind projects. As a result of this update, the company is now seeking a base revenue increase of $4,490,806, partially offset by incremental net wind revenues of $2,728,907. Given the Asbury refund of $924,952, Empire is now projecting an annual retail net revenue increase of $836,947, for an increase of 4.95%, or a monthly increase per customer of $5.09 increase. Now, while we have had the resolution, the partial resolution, if approved by the commission, the non-wind aspects of this docket, this may have changed somewhat these numbers, slightly reducing them, but they do not do away with these large increase to people who reside in what is considered one of the most economically depressed areas of the state of Kansas. So a significant increase to those people if this is allowed at those amounts. And that on top of other issues that may be coming down the pike, as we well know, with the Winter Storm Uri issues. We haven't seen Empire's proposal on that yet, but cumulative effect would be great on when you add all these together. CURB disagrees with many of Empire's wind proposals and believes that the evidence and direct testimony of our witness, Andrea Crane, is filed in this docket, along with any direct questioning by the commission or other parties, will show the wind projects proposed in this case are not needed to serve Kansas ratepayers. The wind projects will increase the company's rate base by over 45%. The wind projects will increase the company's return to the shareholders of approximately $437 million. That's to the total company over the next 30 years. The levelized cost of energy for the wind projects proposed by Empire in its alternative rate-making proposal are significantly different than the levelized cost of energy reflected in the generation fleet savings analysis, also known as GFSA, which was filed to support the economics of this wind project. As proposed, there is no guarantee that ratepayers will experience any savings from these wind projects. However, there is certainty that Empire's shareholders will receive millions of dollars in increased profit. CURB further will assert that should the commission authorize Empire to recover the costs of the wind projects in Kansas jurisdictional rates, it should adopt a levelized cost of energy methodology which provides better protection for ratepayers than the traditional rate-making methodology. Additionally, CURB encourages that should the commission authorize Empire to recover the costs of the wind projects from Kansas jurisdictional customers, then it should authorize a levelized cost of energy charge that is recommended by CURB, which I believe is $23.97, which is the cost of which the generation fleet savings analysis was based. Overall, CURB requests the commission approve the partial unanimous settlement agreement and the aspects of it therein, but deny Empire's application regarding its wind projects. With that, CURB would end its comments. Thank you.
Thank you, Mr. Lund. Our final opening statement will be for the KCC staff. Ms. Mazanthin.
Yes, good morning, Chair King. Good morning, commissioners. I will go ahead and share my screen unless Michelle in IT, do you have the PowerPoint ready to go?
Yes, give me just a second to share here.
Thank you so much. All right. So as the other parties have well covered, the hearing beginning today covers two major topics. First, the unanimous partial settlement, and secondly, the issue of approval of Empire's proposed wind projects. While staff wholeheartedly supports the unanimous partial settlement, staff has very serious concerns with Empire's proposal for its wind projects, which will be addressed herein and further explored in the next several days. Next slide, please. As a bit of background, Empire filed this docket pursuant to KAR 82-1-231B3, which allows a utility that wishes to propose a change in rates within the 12 months following a commission order on its last general rate proceeding to submit schedules that eliminate duplicative data provided in the original schedules, so long as the utility receives permission from the commission to do so, which Empire did, and that the utility is willing to adopt all the regulatory procedures, principles, and rate of return established by the commission in that order. In its order in the 19-223 docket, the commission granted Empire the ability to file the instant application, limiting the proceeding to capturing the revenue requirement impact directly relating to 1, the retirement of Asbury, 2, the acquisition of Neosho Ridge, North Fork Ridge, and Kings Point wind farms, and 3, the non-growth plant and related accumulated depreciation and accumulated deferred income tax balances as of the end of the test year ending June 30th, 2020. Next slide, please. The schedules filed with Empire's application established a gross revenue deficiency of $4.465 million. The gross revenue deficiency was offset by a requested credit to customers of approximately $900,000 relating to the retirement of the Asbury coal plant on March 1st, 2020, and projected wind revenues in the amount of $2.817 million for a net revenue increase to customers of $723,582. On September 15th, 2021, pursuant to the procedural schedule issued by the commission, Empire filed an update to its abbreviated rate application. In its update, Empire increased its revenue deficiency to $4.49 million, reduced its projected net wind revenues to $2,728,907, and increased the net revenue increase to customers to a total of $836,947. As an alternative to including the levelized cost of the wind projects in base rates, Empire proposed using a fixed price purchase power approach, similar to the one approved by the commission in docket number 18-WSEE-328-RTS for Evergy's Western Plains Wind Farm. And Empire proposed a levelized cost of energy of $33.73 per megawatt hour. Next slide, please. On January 14th of this year, staff filed its testimony and exhibits. Staff proposed a gross revenue deficiency of $1.3 million, offset by a credit to customers of $1.497 million, relating to the retirement of Asbury and the projected wind revenues of $2.636 million, for a net revenue decrease of $2.833 million. Staff opposed the wind projects, but if the commission determined to include the wind projects in rates, then Empire's proposal should be adjusted to remove $28.75 million from rate base and $1.58 million in operating expenses relating to the wind projects. And there should be an increased operating expenses by $1.934 million to reflect staff's inclusion of the levelized market competitive purchase power agreement prices for Empire's wind investments in the revenue requirement based upon a market competitive PPA price of $16.32 per megawatt hour. And staff later revised this figure to $15.40 per megawatt hour. Next slide, please. So to first address the unanimous partial settlement, we know the law generally favors compromise and settlement of disputes between parties that enter into an agreement knowingly and in good faith to settle the dispute. Through good faith negotiations, the parties are pleased to have reached a settlement agreement in this docket on all non-win issues, and that is presented before you for approval today. The partial settlement resolves all issues relating to 2 of the 3 issues in the abbreviated rate filing. As you heard from Empire's counsel, the agreement resolves all issues relating to Empire's revenue requirement to account for the retirement of its coal plant and all issues related to capturing the revenue requirement impact directly related to the non-growth plant and related accumulated depreciation and deferred income tax balances as of the end of the test year ending June 30th, 2020. Partial settlement terms are as follows. 1, the Asbury regulatory liability amount related to its retirement shall be netted against Empire's Asbury regulatory asset, so that the net regulatory asset shall be $3,340,140. Empire shall be allowed to recover the regulatory asset over 10 years, beginning on the date in which rates are set from this case, on the date those rates become effective. And due to the netting of the regulatory liability against the regulatory asset, the parties have agreed that Empire's request to implement an Asbury retirement rider is no longer necessary. 2, the resolution of the Asbury regulatory asset and the revenue requirement directly related to non-growth plant and related accumulated depreciation and deferred income tax balances results in a decrease to Empire's revenue requirement of $636,091, which will be allocated among Empire's customers based upon staff's recommendation contained in the direct testimony of staff witness Andrea Jackson, which is to allocate the cost to customer classes based on each class's total base rate revenue from the proof of revenue from the proposed revenue requirement. Notwithstanding the revenue requirement change, Empire shall be allowed to amortize its actual rate case expense incurred by Empire staff and CURB in this proceeding over a 3-year period. 3rd and finally, Empire shall also be allowed to establish a regulatory asset to capture Asbury decommissioning expenses and costs, and Empire shall be allowed to seek recovery of that regulatory asset in its first rate case following completion of decommissioning of Asbury. Next slide, please. The Commission must make an independent finding of 3 things to approve the partial settlement. First, that it is supported by substantial competent evidence in the record as a whole. Second, that it establishes just and reasonable rates. And third, that it is in the public interest. As staff witness Justin Grady covered in his testimony in support of the partial settlement agreement, staff believes the agreement satisfies those 3 conditions and should be approved by the Commission. The partial settlement is supported in the record by Empire's application, direct and rebuttal testimony, as well as the direct testimony from staff and CURB, which offered diverse and conflicting positions about the issues in this case. Further, testimony has been filed by the parties that includes further justifications and support for the agreement. The partial settlement results in just and reasonable rates. The revenue requirement agreed to in the partial settlement is much closer to staff's filed position than Empire's, and staff's direct testimony was filed with the intention of balancing all of the interests represented in this case. The agreed upon revenue requirement strikes the proper balance between Empire's desire to have a reasonable assurance that it will earn sufficient revenues and cash flows to meet its financial obligations, with the need to keep rates as low as possible for ratepayers while reflecting Empire's cost of providing reasonable and efficient service to those ratepayers. The parties to this case had varied and often conflicting interests, and the fact that we have found common ground to resolve those competing interests strongly supports staff's position that the partial settlement will result in just and reasonable rates that are in the public interest. And generally speaking, the public interest is served when ratepayers are protected from unnecessarily high prices, discriminatory prices, and unreliable service. The partial settlement is in the public interest because it reduces the amount of Empire's requested revenue increase while allowing Empire to meet its financial obligations and provide reliable service. The stipulated revenue increase was based upon the record, and we believe it is a reasonable compromise among the parties. Further, approval of the partial settlement would avoid costly and time-consuming litigation, and it is in the public interest to avoid such costs if possible. While we could not resolve all of the issues in this docket through settlement, the number of items eliminated from the list of contested issues greatly reduces the time and expense associated with this evidentiary hearing. Next slide, please. So I will now turn to the bulk of the discussion before us, Empire's wind projects. Ever since 2016, when Empire completed its 2016 Integrated Resource Plan, Empire has been focused on the acquisition and ownership of wind projects, to the detriment of other much more affordable options for Kansas customers, such as purchase power agreements, or PPAs, as I will refer to them hereafter. This focus on ownership prevented Empire from even considering PPAs in its RFP process. A fact that Empire acknowledges, if approved, will ultimately lead to Empire charging its Kansas customers approximately $10 per megawatt hour more than what Empire projects it will be able to sell the energy into the SPP marketplace. But before I detail the problems with Empire's wind application, I'll briefly summarize Empire's proposal. Empire acquired the holding companies for the North Fork Ridge, Kings Point, and Neosho Ridge wind projects during the first half of 2021. This acquisition added a total of 600 megawatts of wind to Empire's generation portfolio. In its application, Empire reflected the investment costs and rate base. Certain wind farm related operations and maintenance expense, depreciation expense, and taxes were also included in the wind revenue requirement for inclusion in Empire's cost of service and base rates. Empire proposed to recover or credit the costs of or revenue generated by the wind projects through its energy cost adjustment rider, should the investment in the wind projects be included in base rates, and plans to sell the energy output of the wind farms into the SPP centralized market price at prevailing prices. To accomplish this acquisition, Empire entered into a tax equity partnership arrangement in which the tax equity partner pays a portion of the capital costs of the assets in return for rights to most of the federal production tax credit value. The essence of this arrangement is that Empire trades the value of the production tax credits for a reduced net investment cost. Ratepayers shoulder a revenue requirement that allows Empire to recover its operating costs plus a return on equity, and the revenue requirement would be offset by the value of the energy from the wind projects that is later sold into SPP. Next slide, please. Staff has several very serious concerns with Empire's proposal. First and foremost, it is important to note that Empire does not need the generation from the wind projects to meet its SPP capacity requirements or to meet its obligations to provide sufficient and efficient service to Kansas customers. Empire has ample energy and capacity for several years to come. Southwest Power Pool's June 2021 Resource Adequacy Report identified Empire's total capacity, capturing the reduction in capacity from the retirement of Asbury, but not yet the addition of the wind projects, at 1,231 megawatts. Empire's reserve margin was identified as 16%, which is 4% higher than its requirement of 12%. This equates to a 43 megawatt capacity excess. Empire's 2019 Integrated Resource Plan projects nearly flat peak load out to 2038, which indicates to staff that there is no immediate need for Empire to add this generation to adequately serve Kansas customers. Empire does not need the wind projects to meet its Missouri renewable energy requirements either. Empire has PPAs in place for Elk River and Meridian Way wind farms, which are both located in Kansas, to provide the non-solar renewable requirements that Empire must meet with respect to its Missouri load. There is not a similar binding renewable requirement in Kansas, but staff believes this is a further illustration of the fact that the wind projects were not necessary for Empire to meet any of its existing obligations. In exploring options for acquiring the wind projects, Empire excluded solicitation of a market competitive PPA. Empire has attempted to justify its decision by stating various reasons why ownership was more beneficial to customers in the long term. But as stated by staff witnesses Nick Puga and Colin Kane, the way to determine the relative merits of utility-owned wind compared to a PPA option is to conduct a comprehensive solicitation that allows a full range of ownership structures, terms, and pricing to be offered. In excluding PPAs entirely, Empire failed to show ownership was actually more beneficial because there was nothing with which to compare ownership. Empire's failure also created a serious gap in their application, which staff witnesses Kane and Puga attempted to fill in using Lawrence Berkeley National Labs data, not Google, as Empire repetitively claimed in its opening. Lawrence Berkeley National Labs is a nationally recognized database, and in fact, Empire witness McMahon used Lawrence Berkeley National Labs data in his direct testimony. Colin Kane and Nick Puga will be happy to discuss this further when they are on the stand. Staff's largest contention with Empire's wind project, though, is its cost. Staff does not have an issue with ownership in itself, but does have an issue with the extreme gap in cost between what ownership costs in this instance versus what a PPA would have cost. As I mentioned previously, as an alternative to putting the wind projects in base rates, Empire also proposed to use a levelized revenue requirement approach, similar to the fixed price PPA approach approved by the Commission in the 18328 docket. Empire determined a levelized cost of energy for the wind projects as part of that alternative was $33.73 per megawatt hour. This is proposed as the fixed price that would be used to recover the cost of the wind projects from ratepayers as an alternative to traditional cost of service rate making. For comparison, the corresponding price for the Western Plains Wind Farm in the 18328 docket was $20.70 per megawatt hour. Next slide, please. Staff witnesses Kane and Puga placed a visual within their direct testimony, which I will show you on the screen now. This chart shows the average PPA pricing executed within SPP territory in dollars per megawatt hour, as shown on the y-axis, from 2017 to 2020, reflected on the x-axis, through 2022. Up in the top right corner, you can see Empire's levelized cost of energy at approximately $33, and how that soars high and above the other numbers reflected on this graph. Next slide, please. Further, on this next slide, you can see the average PPA bids made during the time Empire held its solicitation of ownership opportunities, as reported by the Lawrence Berkeley National Lab PPA price data in the Level 10 marketplace, which is a commonly used reference in the financing of wind projects. For some context, Level 10 P25 PPA prices correspond to those offers in the lower 25th percentile of price in the quarter. But actually, the Level 10 P25 bid offers were consistently higher than the PPAs that were actually executed during the same period. What's reflected in this table here are just the offers that were made. Wind power PPA prices were aggressively bid during the same period that Empire was seeking ownership bids. And Empire could have gone out and gotten a PPA at a price much less than $33 per megawatt hour, $33 per megawatt hour, excuse me. Further, a market competitive PPA price would already include all of the costs necessary to maintain and support the wind assets. PPAs would certainly have been available at significantly lower cost to customers than Empire's ownership of the wind projects. And a PPA which shield customers from a variety of development, operational, and ownership risks. Next slide, please. Here, the unfortunate truth is that Empire's wind project proposal puts all of that risk of ownership on the ratepayers, with no risk to shareholders, other than that the Commission may not approve placing the wind projects into rate base. Empire's hope is that the long-term sales into SPP will be higher than $33 per megawatt hour, but if they aren't, it is the ratepayers who will feel the brunt of that cost. Further, Empire has estimated it will sell the excess energy into the market at approximately $22 per megawatt hour, which is, as I mentioned earlier, $10 less than what they propose the ratepayers pay for that same energy. To staff, the wind project proposal is intolerable. We feel this way for several reasons. One, Empire doesn't need this capacity to serve the very customers who would be paying for it. Two, Empire could have gotten the same wind through a PPA at a significantly lower price. And three, the customers who will be expected to pay for this sit in one of the lower income areas of our state, placing an already overexpensive burden on customers who will suffer more financial impact from this than almost anywhere else in the state. No matter how successful these wind farms may be, the fact is that if Empire is allowed to recover this investment from ratepayers as proposed by the company, the ratepayers will have to cover any losses while shareholders continue to be guaranteed a return on that investment. What Empire failed to mention in its opening statement is that the addition of the wind projects to rate base, according to staff's calculations, would increase Empire's rate base by 50.06%. Staff has never seen a utility request such a large increase at one time. And again, this is happening in one of the most low-income areas of Kansas. Accounting for the reduction in rates that has been agreed to by the partial settlement, the base rate increase associated with wind investments would be approximately $22 per month per customer. Now, to be fair, Empire is confident that the wind farms will produce the revenues to offset that through its energy cost adjustment, to the point where Empire estimates the overall increase will be roughly $5 per month, or approximately $4.25 a month now, if you take into account the partial settlement. But those revenues are speculative and not guaranteed. What is guaranteed is a $22 per month increase, regardless of whether sales into SPP offset that. In conclusion, for all of the reasons listed above, staff opposes Empire's proposal to add its newly acquired wind farms into rate base at this time. Staff does believe that there may be a time in the future where Empire is in need of additional generation to serve its customers and to meet capacity requirements. And at that time, staff would be happy to revisit this issue. In 3 to 5 years, we may also have more information on what the costs are of running these wind farms and a better idea of how successful Empire has been in offsetting the cost by selling into SPP. At this time, however, staff firmly believes this proposal would be a huge detriment to financially vulnerable Kansas ratepayers, with very little, if any, benefit flowing to them in exchange. Staff would request the commission deny Empire's request to add its wind farms to rate base. As to the remaining issues, staff fully supports the partial settlement agreement and requests the commission approve it, as it is supported by substantial competent evidence, it sets just and reasonable rates, and it is in the public interest. Thank you.
Thank you, Ms. Heselton. This now concludes the opening statements. We've been going for approximately 1 hour and 25 minutes at this point, and I believe it's time for a break. So we will do exactly that. Yes, Commissioner Duffy.
Could we have a copy of Ms. Massentine's opening remarks, please?
Yes, Commissioner Duffy, we are planning to circulate that amongst the commissioners and the parties, and I would also move at this time to enter that presentation into the record.
Any objection?
That's staff exhibit 1, excuse me, Chair King.
Fine. Any objection? Without objection, it is admitted. Yes, I think, Carly, that would be very beneficial if you could provide that either to us directly or through Mr. Cohen, whatever is more convenient to you, so we could have access to that. We're going to take a recess at this point, and I think probably in the interest of everybody, we will take a 20-minute recess, and we will resume at 10:45. We're off the record. Thank you. Michelle, can you hear me?
Yes, I can. I was just waiting for you to be back. Ready to
Okay.
start again?
I believe we are. Naola, are you ready?
I'm ready.
All right. It's approximately 10:45, and we're back on the record. As a matter of housekeeping, let me move back very briefly. Mr. Flaherty, Ms. Mazenton had entered into the record her PowerPoints. Do you wish to do the same?
Sure. I've always wanted to be in the record. So, yeah. So I will, if we could have the court reporter mark that as Empire Exhibit number 10, because we've pre-marked some other exhibits, I would ask that PowerPoint presentation, which I assume you received, be marked as Empire Exhibit number 10 and be admitted into the record.
We have received it. It would be marked as exhibit number 10. Is there any objection to its admission? Without objection, it is admitted. All right, thank you, Jim.
Chair
Carl?
Keen.
Yes.
Chair Keen and Commissioners, I have a further preliminary matter regarding the order of witnesses I would like to discuss, if that's okay.
Briefly.
Okay. At the pre-hearing conference with the original order of witnesses, the reason it was set up that way is because Empire's witnesses had availability issues, and so they were going to be spread across 3 days. And so staff accommodated those issues. However, over the course of the subsequent days, the availability issues have changed. And as a result of that, the order of witnesses in staff's opinion needs to be modified from that which is in the script. Traditionally, the company presents its case first, and the changes we would propose are consistent with that. So we would propose keeping the first 4 witnesses the same up to Aaron Dahl, at which point then we would request that the remaining Empire witnesses, James McMahon, Todd Mooney, and Greg Tillman, are up, followed by Curb and then staff's witnesses, as is consistent with prior hearing procedure.
Mr. Flaherty?
Yeah, as long as that, I guess, order doesn't interfere with, I know Mr. McMahon is available Wednesday morning, and Mr. Mooney was not available Thursday morning. So as long as that that order doesn't interfere with their availability, we have no objection to doing that.
Is Mr. Kind of inform the commission here a little more specifically, if you would. Is Mr. McMahon and Mr. Mooney, are they available today?
They are not. So Mr. McMahon is available Wednesday morning. And Mr. Mooney was originally only available on Thursday. He's now available on Wednesday all day and anytime Thursday afternoon. So if, just depending on how this proceeds, if we get through the 4 witnesses today and we end today, then we can start with Mr. McMahon on Wednesday morning, take Mr. Mooney afterwards, and then Mr. Tillman, just like staff wanted to do.
All right, I think what I will do, I'm going to take this under advisement. Let's see how we proceed. Let's see how the testimony proceeds, how quickly it proceeds or not quickly, and then we'll make a determination on this. I think we can postpone that determination at least into the afternoon. So that's what we will do.
Commissioner,
Thank you.
All right. Thanks
Commissioner
very
Keen, this is Todd Love. I do.
Yes.
I know everybody else was mentioning their witnesses. Andrea Crane, we brought this up at the pre-hearing. She is not available at all on Thursday. So obviously we would need to get her in either today or tomorrow.
Well, I would think that's easy.
I would hope so, but you never know.
I'm not going to condemn a result by making a prediction that turns out to be incorrect, but I'm optimistic that will be able to be accomplished.
Thank you. I just wanted to bring it up. Thank you.
All right, very good. All right, let's now turn to the examination of witnesses. And Mr. Flaherty, would you please call your first witness?
Yes, thank you, Your Honor. Empire would call Mr. Tim Wilson.
Mr. Wilson, I need to swear you in if you'd raise your right hand. Do you solemnly swear the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Can you please state your name and business address?
My name is Timothy N. Wilson, and my business address is 602 South Joplin Avenue, Joplin, Missouri, 64801.
By whom are you employed?
I'm employed by Liberty Utilities Service Corp. as the Vice President of Electric Operations for Liberty Utilities Co. in the Central Region.
In that capacity, did you submit pre-filed direct testimony on behalf of the Empire District Electric Company in this docket?
I did.
Do you have any changes or corrections to your pre-filed direct testimony?
I do not.
If I were to ask you the questions that are set forth in your pre-filed testimony, would your answers be the same today?
Yes.
Your Honor, I would request that Mr. Wilson's pre-filed direct testimony be referred into the record.
Is there any objection? Without objection, it's admitted.
And I would tender him for questions. Thank you.
All right, very well. We will now begin the cross-examination, and we'll start with the commissioner questions. And I will begin first with Commissioner Duffy.
Thank you, Mr. Chairman. I do not have questions at this time. I may after further testimony. Thank you.
Fair enough. Commissioner French.
I have no questions for Mr. Wilson. Thank you.
All right. Well, it's 3 on a match. I have no questions for Mr. Wilson either. We will turn to, I guess, for cross-examination, we'll turn to Curb. Mr. Love.
Thank you. Mr. Wilson, my name is Todd Love. I'm one of the attorneys for Curb, and I do have a few questions for you if you're ready.
Yes, sir.
On page 12 of your testimony, lines 19 and 20, you state that under the company's original proposal, the average residential customer would see an increase of $4.97 or a 4.4% a month increase based on a 924 kilowatt hours. Is that correct?
Yes, I show it as page 12 of my testimony.
Oh, okay. I apologize. And also, and I know you didn't file this testimony, but perhaps you know, in Tisha Sanderson's testimony that was being adopted by Mr. Tillman, updated those impacts in her supplemental testimony on page 6. Are you aware of that?
I am aware of that. It is not in front of me.
Okay. Do you know if the amount she updated those to would be about $5.09 a month?
That is correct.
Okay. Thank you. Now, have you recalculated the rate impact based on the provisions of the non-wind settlement, assuming that the wind projects were entirely excluded from base rates? Excuse me.
Could you repeat the question? I guess, okay. Are you asking me have we recalculated rate impacts if for some reason these wind farms would not be included in rate base?
Correct.
I have not.
Okay, thank you. And have you recalculated the rate impacts based on the provisions of the non-wind settlement, assuming that the wind projects are included in the company's base rates?
I'm confused by your question there.
Okay.
I'm sorry. I've never thought of this as being not included in rate base. So,
okay. Well, I guess the question would be did the non-wind settlement impact the monthly amount a customer would be owing?
What are you referring to as the non-wind settlement?
The non-wind settlement, meaning the Asbury retirement, the partial settlement in this docket.
Yes, we believe that, as we've shown in the GFSA, that rates would be higher than if we had the wind farms in place.
Okay. Empire initially sought pre-approval of the wind projects in the KCC docket in 18 EPDE 184 PRE that was filed on October 17th, 2017. Is that correct?
That is correct.
And after testimony was filed by staff and interveners in that case, but prior to the commission decision, the company withdrew that application. Is that correct?
That's correct.
Do you know the reasons why it was withdrawn?
I would have to be sure with legal, but I don't think it was required. Whereas Missouri, we required a CCN, and we went through the CCN docket in Missouri. It was not required in Kansas, and therefore the parties agreed to not proceed with that docket.
Okay. Were you involved with that decision regarding the withdrawal of the application?
Yes.
So the company, you withdrew the application, so the company went ahead and completed these projects even though they didn't receive pre-approval from the KCC. Is that correct?
That is correct, because it was not required.
In evaluating the additions of wind, Empire did not, sorry. In evaluating the additions of wind, Empire did not solicit proposals for purchase power agreements. Is that correct?
That is correct.
So Empire always intended to own these projects. Is that correct?
We did.
Were you involved in the decision not to solicit purchase power agreements?
Yes, I was.
Okay. Who made that ultimate decision? Was that a group decision or a specific person? Or
Oh, it was a group decision, but it was a pretty easy one.
understood. Your Honor, I do not believe I have any further questions for Mr. Wilson.
Thank you, Mr. Lund. Cross-examination, KCC staff.
KCC staff does not have any questions for Mr. Wilson.
All right. Before I move to redirect, let me go back to the commissioners. Do either of you have some questions you'd like to ask of this witness? Commissioner French.
Just one quick clarification, Mr. Wilson. I think in response to one of Mr. Love's questions, you said, I think he was getting at what the rate impact would be if for some reason the wind farms were excluded from rates. And I think your response was that rates would be higher without these wind projects. My understanding is that comparison was operating the wind projects versus continued operation of the Asbury plant. Is that correct?
That is correct.
Okay, so that would not be so it would not be a comparison of a baseline of retiring the Asbury plant and then a comparison of either adding or not adding the wind projects. Does that make sense?
Correct. So even if we had continued to retire Asbury and not build the wind, what we have shown is, and I would love to get into it more, hopefully in redirect I will, that we're not talking about rates just today. We're talking about rates over the next 20 and 30 years. And we have clearly shown throughout our GFSA docket, as well as our Missouri docket, as well as in this docket, that this provides our customers savings. So had Asbury still been running and we didn't build the wind farms, our rates would be higher than they would be otherwise now moving into the future on a net present value of revenue requirement basis.
I'm having a hard time following that. So if they are not included in rates,
over time, if they're not included in rates, because we've shown they provide savings, if we don't have those savings and they're not achieved, therefore, over time, rates will be higher than they would have been otherwise had we had the wind farms in rates.
so if you had not built the wind farms and you were relying on your current capacity plus supplementing it with whatever market energy is, that would be, you're saying that is higher tomorrow.
Right. And this gets into the other half of the equation that staff witness, Mr. Kane and Mr. Puga, as well as others are not getting into, is the revenue. So if you don't have that, you still have to provide that energy somehow, right? And the marginal cost of energy, if you assume it's $23 a megawatt hour right now, you're not getting the revenues associated from the wind. So even if you're saying, making the argument that the wind are only providing $18 a megawatt hour in revenue, that's revenue that you wouldn't be getting. So you have $23 as replacement power. And then you're missing out on the $18 of revenue from your wind farms had you had them, which is way more than the $33.73 that we've proposed in this case.
I'm having a hard time following that rationale. You may have to clean that up for me on redirect.
Okay, maybe put differently. If the wind farms are not there, they were providing energy. You still have to provide whatever energy they would have provided to your customers from some other source. Let's say that source is at the marginal price of $23 a megawatt hour. So your customers are going to pay in the ECA, the $23 a megawatt hour. But because you don't have the wind farms there and you're not receiving revenue, even if you assume $18, which is assumed to be low market revenue, your customers are missing out on that revenue piece. So the $23 they're paying for their replacement power plus the lost potential in revenue from the wind of $18 is well more than the $33.73 we have proposed as a 20-year number hedge moving forward on a revenue requirement basis for these wind farms.
So the idea is there is enough excess revenue or excess off-system sales that's going to create a net savings.
It's more of the energy and revenues that the wind farms will receive. All we've been talking about is PPA costs, right? But they're not talking about revenues. That's the other side of the equation that for some reason the company is the only one talking about. You can have a wind farm that let's say Western Plains, for example, that's $20.70 a megawatt hour. That's in base rates. But for example, in witness, Aaron Dole can get into some specific actual examples. If your customers are paying $20.70 a megawatt hour for that, but they're only getting, say, $5 a megawatt hour in revenue, you got to find $15 on top of that through the ECA to make the company whole on that. So it's not really $20.70, it's over $30 because of revenue. And that's what we're talking about, and Mr. Flaherty was talking about in his opening remarks, is it's not just the cost, it's not just the PPA, it's the revenues associated with it. And you have the ECA there that balances that out.
So what I'm having a hard time following is if the levelized cost of energy associated with the wind farms is $33 or somewhere in that range, and the market price, it is relatively high, I know, in the Empire area in your node. If it's, say, $22, I think staff indicated in their statement. How is that? I'm just trying to figure out how that's that you're coming out ahead at that point. I mean, I know it is creating revenue. I mean, you are getting the $22.
Right, and in that scenario, we're not covering what the PPA is, but that's a snapshot in time. What we're saying is our analysis is not done just for today, right? I don't know what natural gas prices are going to be tomorrow. I know for the next 20 years what the price of this wind is going to be. And our analysis has shown multiple times in multiple dockets that even at $33.73 over time is going to save our customers money. I don't think that anyone believes with natural gas prices, gasoline, oil, whatever it is, moving forward, that these prices are going to remain. This is a hedge.
I may ask that this question is probably better for Mr. Dahl or Mr. McMahon, but did you all do an analysis of congestion being relieved within the SPP region over time? I know there's some pretty big investments planned in your area, and the fact that your node prices may actually be coming down significantly in the future.
So there are what the SPP refers to as ITP studies, and that we took into consideration, and witness Rooney can get into the details of how we use SPP information and future projects in our analysis in determining which one of these we should have selected. Having said that, again, it's a forecast. You got to assume, certain generators may or may not get built. You got to assume certain, but we did the best with what we could in terms of trying to predict the, transmission congestion in the SPP.
Okay. All right. I think that's all I have. Thank you.
Yep.
Thank you. Commissioner Duffy?
Good morning, Mr. Wilson. Okay, following along where Commissioner French was going. So when you say you're looking at it over a 20-year time period, is it really 20 years? Or, I read in the material and that the repurposing of the wind turbines is actually occurring in a lot of them in year 14. So it's not a 20-year time frame. So is the repurpose costs where you're making it more viable, so the turbine itself, so that there's more wind generation ability? Is that factored in at this point in time?
No, it's not. And I want to be clear that actually the fact that we're talking about 20 years and not really 30, actually, when you go out that far, it makes these projects look even better. The minimum design criteria we established in our RFP to construct these wind farms was 30 years. So our customers aren't just going to get benefits for 20, or as within the PPA cases that Mr. Kane and Mr. Puga showed, 14 years. We're going out and we've designed this for 30 years. So when we talk about 20 years, we're really not giving ourselves enough credit. Having said that, if a point in time when repurposing or retrofitting these wind farms would become economic for our customers, we would certainly look at it. Right now, that's not involved. That's not included in any of the analysis.
Okay. All right. Let's talk about the PPAs that you didn't look at. I think the comment was made earlier this morning from Mr. Flaherty that potentially these PPAs, there is no weatherization of the generation, the third-party generation units. Do you know that for a fact that companies who have PPAs are contracting with the company that has not weatherized their equipment?
So that was an option in the design criteria. We selected it. I can tell you, if you're trying to build something as cheaply as you possibly can, like the folks down in Texas did, that everything froze up and they were take or pay, and folks lost a lot of money because they weren't generating, that it becomes an issue. And those wind farms did not have cold weather packages on them.
Okay, but what about in Kansas? Do you know, do any of them have weatherization?
I cannot speak to the specific design criteria of someone else's wind farm.
What about where you currently have your PPAs? Are those weatherized?
I would have to defer that to Witness Dole or Witness Rooney.
Okay.
We entered into those contracts in 2000, before 2010, so I don't recall exactly what they have. I'm pretty sure that they do, but you don't go on the record and say pretty sure, so I would ask them.
Okay, and yeah, just to let whoever has the answer, I would like to know the answer to that. So assuming then that if they do, that is built into the cost, the additional hardware, whatever it took, the package to add that. So it's my understanding those PPAs are coming to an end of their contract. And at that point in time, you will let them expire.
Yeah, both of them starting in 2023. I won't give the specific because it's highly confidential. But starting in 2023, these wind farms that staff has referred to as saying that because we have those, we don't need this, ironically are more expensive than what we propose for these wind farms today. And what we propose for our wind farms is 20 years.
Potentially, if you would, let's say you didn't build the wind farms and you went under another contract, could the price be lower? for the Riverton and the other wind farm you have where you're receiving your PPA?
I'm going to make a correction there. So we don't have a wind farm at Riverton.
Oh, well, your
We have-
PPA, wherever your PPAs are.
Okay, so Elk River and Meridian Way. One's in
River.
Belmont, Kansas, and one's in
Right.
Concordia, Kansas.
Yes, potentially could they be contracted at a lower price?
So we did look into repurposing those, and all they wanted to do was extend our PPA for higher cost, but that is something we looked into.
For a higher cost,
Correct.
okay? Let me switch gears a little bit. As we look at the part of the plant there at Asbury that you're looking to turn into an energy center, how many FTE are we talking about?
Right. So we have what we call the Asbury Renewable Operations Center. We call it the AROC. Something
Okay.
we're proud of. We repurposed the maintenance facility that was at Asbury. We've repurposed the offices in that area at Asbury. So those weren't stranded assets. We've repurposed them, and we operate our wind farms out of there. Traditionally at Asbury, at the coal fire facility, we would have around 62 FTEs. And we promised them that moving forward, because the way we were locating these here, and we're going to operate them ourselves, that no one would lose their job. And that's one of the things that I am most proud of throughout this entire thing, is not only being able to provide our customers, economical and cost savings over the next 20 years energy, is that from a personal perspective, not one person lost their job. Through attrition, we got from 62 down to about 30, which was a minimum operating. From a safety perspective, that was about the minimum staffing level we had. And to get to your question, current FTEs at the AROC is around 26, give or take what day it is. And they
Okay,
not only operate those wind farms, we also have, because they had such a good skill set to operate fossil fuel, is we have the ability to use those employees to be like a roving maintenance crew. So when we have a major outage at State Line Combined Cycle, which is only 28 miles or so away from Asbury, when we have an outage at the Riverton Combined Cycle, when we have an outage at the Energy Center, they can go and assist with that and compress the time frame by which they're on outage.
and that would be in lieu of just the folks at those two sites doing it themselves.
And or additional contractors, yes.
Okay, so somebody also in their testimony talked about that you're going to evaluate whether it really does make sense to keep these as FTE or whether you should employ the third party option to run the wind farm.
Yeah, so right now, in order to keep and maintain our warranties from Vestas, who is the equipment manufacturer, they're required to be the third party that we hire to perform our maintenance on the turbines in order to keep our warranties. Moving forward, actually the opposite. If we can do it for cheaper ourselves, we may hire more to maintain the actual equipment. But if at some point in time we deem we can save our customers by going third party for the entire operations, we would look into that.
Okay, all right. Okay, so you've got these two wind farms and you're selling wind on the market, but it appears in a study that your need for increased generation, increased power, actually the wind farm, the data showed that you're flat in Missouri's IRP, that for the next 38 years, you're really not looking at growth. And we know in that part of Kansas, even though we're a small part, we're struggling to keep the number of residents in that part of the state. And population decline is a real issue for the state of Kansas. I don't know really about Missouri, but you reflected really no growth. And
Yeah.
so how do you justify? And it appeared that you really didn't need these wind farms and the additional generation.
Well, first of all, I completely understand your comment because I actually live in that part of Southeast Kansas, in Riverton, Kansas. Very proud school board member there. And
Yeah,
so
that's why it was on my mind.
I know exactly what you're talking about, and I would love to have more growth over there because I think we have the best school district in the state. Having said that, what you're referring to is a customer growth. It probably looks flat when you're looking at it over 20 or 30 years. It's not completely flat. However, I think what you're referring to is the SPP required planning reserve margin, and they're saying that these just weren't needed. We didn't need the capacity. My first point I would like to make is we need to probably clear that up. Witness Dole can clear that up. If we don't have the wind farms, we would be short on that planning reserve margin this year. So we do need the capacity. So I want to make sure that we get to that with Witness Dole. But let's just say that we don't. The old way of doing integrated resource planning, when you only build something because you need capacity and not considering the energy portion, which is a large part of the bill, that's archaic. You have to take a look at things not only from a capacity perspective, but what is the cheapest way you can deliver megawatt hours to your customers? That's what this wind does, regardless if you need capacity or not. It's about reducing the energy cost and the ECA for your customers over the next 20 and 30 years.
I don't disagree with that at all, but why 3 wind farms? Why not 1?
Well, we determined that 600 megawatts was the right amount. And so if you have 600 megawatts, you could do 1, you could do 2, you could do 3. If you have 600 megawatts at one facility, you don't have location diversity, okay? All of the wind is the same on that 600 megawatts, whereas if you have a little bit of location diversity, you can balance that out a little bit more. And if you have a major outage, you've lost all 600 megawatts. So location diversity is very important, as well as location diversity from market prices. If you're at one place and the market prices are bad and you haven't hedged by spreading them out, then that's going to be bad for your customers. So that's why we went with 3. We identified 600 megawatts and we selected the portfolio that was best for what we felt was for our customers.
In your portfolio, do you plan on keeping the other plants operating as you go forward?
So we're currently going through our triennial integrated resource plan in the state of Missouri. I believe it's due here in about a month. What it will say, well, I should probably not say what it will say. Let's go back to 2019. There were some retirements in the 2019 preferred plan. It was a couple of simple cycle gas turbines. We're reevaluating that at the moment, but that will all be publicly available once we complete the triennial update. There are planned retirements in the near term and out into the future for our generation portfolio.
Okay, so you're filing that in April, correct?
Correct. I believe it's April.
Okay. Following up on that, is storage contemplated at the Asbury site or anywhere else in your plan to accommodate these wind farms?
Absolutely. We are looking into that, trying to figure out the right amount, which again goes back to why we didn't, first off, we didn't need to seek a purchase power agreement because it's not like someone's going to give you a cheaper PPA than what they would build it for you. It's just a different financing mechanism. But by owning it, you get the same price at that location, but you get so many more benefits. And when you bring up the fact that have we considered storage, the fact that we own the interconnect from ownership, that allows us to co-locate at the wind farms, solar and storage, a combination of those. As you guys know, in the SPP interconnect, GIA it took us 5 years to get these for the wind farms. Sometimes you don't have 5 years to do what's best for your customers. The beauty of having these wind farms is obviously they're not at full capacity, 365, right? So whenever they're not running at full capacity, you can co-locate and maximize the value of that interconnect point. If we had a PPA, we wouldn't have that ability. That's just one of the many things that are so much better for our customers about owning versus having a PPA. So I appreciate the question. We are looking into storage heavily.
So where would the storage be placed? There at the farm or there at the Asbury site?
We would have to do a study to determine what's best for that, depending on, where you interconnect. I would assume it would be close to the substation. There, it's safer at Asbury. North Fork Ridge, their interconnect point is at Asbury. Again, another beauty of having an ownership in an LGIA, we were essentially able to transfer Asbury's GIA to this wind farm at negligible costs. So we would have to do an engineering study to figure out exactly where it would be. But certainly we're looking at co-location and maximizing the value of our owned GIA.
Okay. And finally, SPP's given you the thumbs up for being in the queue and for the generation from all 3 wind farms, correct?
Yes, we have signed interconnect agreements for all 3 wind farms.
Okay. And you are now fully operational, is that correct, right now?
Correct.
And have been since April of last year, is that right?
I would say 80 to 90% as of April. You can be commercial and still have a few bugs you're working out, but for all intents and purposes, by last April-ish timeframe, we were in full commercial operation moving forward.
Okay. I do want to turn to the coal plant that you've retired. Okay. I was like shocked to see how much it had degraded in terms of the value and the output and the run. I mean, that was like, what were your folks doing since it was down most of the time?
They
Or
were
half the
performing maintenance, and I think you guys have seen in other utilities across the state, folks are dealing with this and they're having a hard time making a decision because people are involved and it's already in rate base. So it's really safe to just keep the status quo. We went out on a limb and said, we have something that's already in rate base, but it's not what's best for our customers.
So you did do some retrofit and it was like, you put it on steroids. Was that in your mind always a temporary fix?
No.
No.
We at the time we made the decision in a 2010-11 timeframe to add air quality control systems at Asbury in the 2014-15 timeframe, we had to comply with the mercury and air toxic standard rule. So you either have to comply with this or you retire it and replace it. At that time, the economics showed you retrofit that thing and not replace it. So we put $121 million with AFUDC into this unit. That's total cost, not just Kansas. And that was the right thing for customers. We never dreamed that we would be retiring it, some 5-6 years later. But the market conditions changed drastically, as you've seen in other dockets and with other utilities. And we went out on a limb. We knew folks would say, well, you just put this money into there. Even after putting that money into that, the analysis we performed showed that it would save our customers money, even after retrofitting, because moving forward, we were still going to have to put significant capital into that unit as well for compliance with ELG, effluent limitation guidelines, as well as CCR, the coal combustion residuals rule. We still had more money to invest. So investing more money into that plant on top of its degrading economics, as you've talked about, we went out on a limb and said, this is what's best for our customers. We're going to retire this and replace this with 600 megawatts of wind, which has brought us to where we are today.
Okay. Let me ask you on the decommissioning costs. Do you see anything extraordinary out there that you had not planned on related maybe to your coal residue? Or I know you cited asbestos in the building that adds to cost, I'm assuming. But is there anything else that is unusual about the decommissioning of this plant?
No, there's not. We have an ARO already established on the books, and witness Landau could probably speak more if you need to really get into the details of the decommissioning, but there's nothing in the studies that we've done right now that surprised us. We always knew we were going to have asbestos remediation. We always knew we were going to have to close and cap our ash impoundment. So all those things we already knew. There's not been any surprises that have surfaced.
Mr. Chairman, I think that completes my questioning, and I thank you, Mr. Wilson.
And I thank you too. It's one thing. I've been in multiple hearings, and rarely do all three or all five or however many commissioners are actually there. So I really appreciate our alignment in the importance of this proceeding as it relates to our customers. So I'd be remiss if I didn't thank the three commissioners for actually being here. It's fun.
Thank you.
Thank you, Commissioner Debbie. I think hopefully we're more than just here. I know you didn't mean it that way. Mr. Wilson, I have a few follow-up questions for you as well. And mine dovetail. You've answered virtually all of the questions I had in responses to the other two commissioners. So what I have one kind of cleanup question to ask of you. I don't mean to be repetitive by asking it, but I would just like a holistic answer from you. And I appreciate the candor of your responses, quite frankly. And what I want you to do is address rather specifically two of the concerns that were raised by the staff. These both, I think, are interrelated. One is the contention that Empire's wind farms are very expensive compared to other available options. And I think a related concern that the staff expressed was that by virtue of, and I'm trying to, that by having these wind farms that are owned by Empire, that it results in ratepayers shouldering the burden of any loss while shareholders are guaranteed a return. If you could respond to these contentions by the staff, I would appreciate it.
So could you repeat the first part of your question? The fact that I think what it was they contend that they're expensive, right?
Yes, the contention was that the wind farms, that would be your wind farms, and I think that alludes to the ones that are owned by Empire, are very expensive compared to other available options.
Right. And again, this goes back to, for some reason, and I don't understand it, and I hope, I'm sure we'll get to it in further testimony, but staff and staff witnesses, Kane and Puga, are only looking at half of the equation. They're only looking at cost. They're discrediting revenue, and you just can't do that. You can have something that costs $20 a megawatt hour that your customers are hedged at $20 a megawatt hour, as in the case of Western Plains. But if you're only getting $5 in revenue for it, the customers have to make up the shortfall. So they're not paying 20, they're paying 35. Same thing with ours. You can't just say $33.73 is expensive without looking at the revenue piece that you're actually getting back. There are, and Witness Dole can really get into the details here, and you'll probably have to stop him. He'll really get into the details, but we can clearly explain how $33.73 it could actually not only be as good, potentially better than something that's $20.70. You have to take in both sides of it, not only the cost, but the revenue side as well.
Thank you. I appreciate your response. That ends the questions I have that otherwise it'd be repetitive. I'll turn to you now, Mr. Flaherty, redirect.
Thank you, Your Honor. I just have a few questions for Mr. Wilson. Mr. Wilson, Mr. Love asked you whether or not Empire solicited or did an RFP for PPAs, and you indicated that Empire did not do that. Do you recall that questioning?
I do.
And can you explain why Empire did not do an RFP for a PPA at the time it did the RFPs for the ownership option?
The simple answer is we didn't need to. First off, there was no requirement, but second of all, the way we've constructed using tax equity, back calculating a net present value of revenue requirement over 20 years is quite simply the same thing as a PPA. So it would be duplicative of the efforts. And certainly it completely wasn't needed because, again, you're not going to get someone to offer you a PPA cheaper than what they can build it for. It's just a different way of financing it. It's on one person's book versus the other. It wasn't needed.
And Commissioner French asked you some questions regarding, I guess he was trying to struggle as to how can you have a plant that costs $33 and you're only receiving $18 in revenues, how can that end up being cost savings to the customers? And I think you're trying to explain to him that you have to take into account the avoided cost. And so I wanted to add, do you recall those questions?
I do.
Yeah, so let me, if I can have Amy, if she can share her screen, pull up Empire Exhibit number 1, which is Mr. Grady's testimony in that Western Plains case. And maybe Mr. Grady can, as he's always willing to do, help us out, maybe answering Commissioner French's question by looking at his testimony that he filed in that case, because that same issue came up in that case as to how you could, have a wind farm at $20 and only, getting revenues of $4. How could that be create any savings to customers? So let me just turn your direction to page 21 of Mr. Grady's testimony, which is Empire Exhibit 1. And starting on line 11. Yeah, I think it's one more page down, or yeah, you're going the right way. Yeah, right there. Stop. Yeah. So, and hopefully the commission received these exhibits, but it's up on the screen there. So, Mr. Wilson, if you could just to yourself, maybe read that question that was asked by Mr. Grady in this Western Plains case to yourself, and then maybe I'll ask you if that's what you were trying to explain to Commissioner French about how you could have savings if the plant costs $20 and you're only getting $4 worth of SPPIM revenue.
Correct.
Let me know when you're done there.
That is another way of putting the generic example that I gave with actual numbers from an already commission approved PPA, similar to what we're trying to get done, established in this docket.
Okay. So Mr. Grady explains that in addition to taking, in this case, the $5 million in SPPIM revenues, you also had to consider the avoided cost. In other words, what customers would have paid if they didn't have that wind energy, which I think you indicated for Empire was around $23. And then when you combine those two, that's what you then compare to the $20.24 to determine whether or not there's savings, correct?
Correct. That's what they did.
Yeah. You all right? Move for the admission of Empire Exhibit number 1. And thank you, Mr. Grady.
Is there any objection? Without objection, it's admitted.
Thank you. And that's all the questions I have. Thank you, Mr. Wilson.
All right, thank you. I think in the interest of closure.
Chair Keen, may I ask one follow-up to that?
Oh, absolutely.
Description.
Please.
Thank you.
Please, Commissioner.
I guess just for clarity, I appreciate all this. I mean, I think you can tell I just have frustration of no apples to apples comparison here. I mean, I agree. When evaluating wind farm ownership, you have to take into consideration revenues that can be produced, or the full perspective of benefits. And I agree that you are differently situated than a wind farm located in where something like Western Plains would be located. I guess the only it's not a distinction, or maybe I'm asking you whether it's a distinction. In a situation, if you didn't have a capacity shortfall, and you just, I guess, for energy, be relying on whatever is available to you in the market, is your avoided cost the same as what Westar's avoided cost was there, or is your avoided cost just whatever the marginal price of energy is in the marketplace available at your node?
latter.
Does that question make sense?
Yeah, the latter, it'd be similar.
Okay.
It's an incremental cost of a megawatt hour at your load node.
Okay, thank you. That's all I had.
Thank you. Commissioner Duffy.
On that last exhibit, I would just prime Justin, I'm sure he's gonna maybe speak to it, but it said avoided costs from other generating facilities. And I'm not sure what those were or are or whatever. So I would like some clarification of what that exactly meant. So.
Your Honor, if I can follow up with Mr. Wilson, let's see, let's put up Empire Exhibit. Let's see, number 2, if we can.
Mr. Wilson had the bad luck of going first.
He did. That always happens.
Commissioner French, I'm a glass half full guy, and if it's not, just get a smaller glass. The way I look at it is I may be done soon. So
Mr. Wilson, this is Dr. Glass's testimony in that same docket, and he actually explains how the staff in this case identified the avoided cost. And again, we can have Dr. Glass help us answer that question. And let me see. Amy, could you stroll to the first part, the first page of Dr. Glass's testimony? Okay. Yeah, and if you could stroll down to hold on, let me pull that up. Just a second. Okay, and starting at page 5, the bottom of page 5. Yeah, you just went past it there. So yeah, so Mr. Wilson, if I could ask you, if you could read Dr. Glass's testimony, starting on page 5, line 16, and then down to the next page, page 6, line 5. I want to ask you a question about that. Let me know after you've read that.
I've read that part.
Okay, and so is your understanding that the way Dr. Glass determined in this particular case regarding this wind farm, what avoided production cost was for Westar, that he simply used Westar's ECA?
Objection to the fact that this witness cannot testify as to Dr. Glass's testimony in this docket.
Lardner. Mr. Flag. Oh, sorry.
Well, I mean, the Commissioner Duffy asked the question about what this avoided production cost was in this Western Resource or Western Plains case. And so I'm just trying to help her out with that, answering that question. If Mr. Wilson can certainly look to see what Dr. Glass used to determine that, that's in Mr. Grady's testimony, and he can give his opinion as to, how in reading that, how Dr. Glass, based upon his reading of Dr. Glass's testimony, determined the avoided production cost.
I'm going to overrule the objection. I think we can note certainly that Mr. Wilson's response is his opinion. Mr. Wilson, please.
Yeah, I mean, fuel and O&M costs are the main components of avoided costs, and it appears from this testimony that that's what they used and based it upon the PCA.
Okay, thank you. That's all I have.
All right, thank you.
Oh, I would move for admission of Empire Exhibit number 2.
Is there any objection? Without objection, it's admitted. All right. Mr. Wilson, in the interest of closure and completeness here, I'm going to visit on you just a little bit more of this agony of being the first witness. And in fairness, appreciate your attitude. In fairness, I'm going to turn back to Mr. Love and Curb. Do you have any recross?
Excuse me, Your Honor, I couldn't get my mute button off. I apologize. I do not.
Very well. KCC staff, any recross?
Commission staff does have recross from Mr. Wilson. Mr. Wilson, good morning.
Good morning.
Mr. Wilson, in response to one of Commissioner Duffy's questions, you stated that without the wind farms, Empire would be short of capacity with SPP for purposes of Empire's planning reserve margin, quote, this year. Can you help me find where in the record Empire has stated it will not meet capacity requirements without the wind farms, quote, this year?
Yeah, I referred to witness Dole to describe that, but I don't believe that there's anything on the record written currently that establishes that. I think on the record, witnesses pointed to some data that may be a little bit old, and that may not include a capacity sale that we currently have. And so I believe he could certainly clear all of that up. I think that's what the difference in components is with respect to the minimum planning reserve margin as required by the SPP.
So, Mr. Wilson, I just want to make sure, to your knowledge, there is no information in the record that states that Empire will not meet its capacity requirements without the wind farms this year.
I agree that I don't believe I've seen that anywhere on record. That's why I wanted to clarify that and make the point of, even if we don't, or even if we did meet the planning reserve margin, there are still significant other benefits. So either way, our customers benefit from it.
Mr. Wilson, my next question for you is, can you point to where in the record Empire has provided information regarding reductions in avoided production costs similar to Western Plains?
I can't off the top of my head throughout the multiple documents I have here refer to something specifically with regard to the granularity that you asked.
Staff has no further questions.
All right, thank you. Thank you very much. Mr. Flaherty, any review direct?
No, thank you, Your Honor.
Very well. Mr. Wilson, I believe we've come to an end of your testimony. We appreciate very much your indulgence of our questions. We appreciate your appearance here this morning, and you are excused and you may virtually step down.
Thank you very much, Chairman, and I appreciate again everyone's thoughts and consideration today. Be safe.
Very well, thank you. All right. It's about 11:45. My inclination is to proceed a bit further. So I will turn back to you again, Mr. Flaherty, and ask if you would call your next witness.
Thank you, Your Honor. Empire would call Sean Rooney.
Mr. Rooney, I need to swear you in if you'd raise your right hand. Do you solemnly swear the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Can you please state your name and business address?
Yeah, my name is Sean Rooney. My business address is 602 South Joplin Avenue, Joplin, Missouri.
By whom are you employed?
I'm employed by Liberty Utility Service Corp. As the Senior Manager of Strategic Project for Liberty's Central Region.
In that capacity, did you submit pre-filed direct testimony on behalf of the Empire District Electric Company in this docket?
I did.
Do you have any changes or corrections to your pre-filed direct testimony?
I do not.
If I were to ask you questions that are set forth in your pre-filed direct testimony, would your answers be the same today?
With the exception of there was a question relating to production to date. Obviously, with the passage of time, those numbers would be different.
Okay. Did you also submit pre-filed rebuttal testimony on behalf of Empire in this docket?
I did.
And do you have any changes or corrections to your pre-filed rebuttal testimony?
I do not.
If I were to ask you questions that are set forth in your pre-filed rebuttal testimony, would your answers be the same today?
Yes, sir.
Mr. Chairman, I would request that Mr. Rooney's pre-filed direct and rebuttal testimony be referred into the record.
Is there any objection? Without objection, all of that will be included in the record.
And I would tender Mr. Rooney for questions.
All right, very well, thank you. Cross-examination, I'll turn first to the commissioners and see if they have any questions to begin. Beginning this time with Commissioner French.
I'll reserve any questions till after cross. Thanks. Thank you.
Okay, Commissioner Duffy.
I'll reserve the bulk of my questions for after later, but I do have a question. Did the wind farm projects come in on at the estimated cost they were supposed to?
No, there were some increases in cost during the construction and development of the project.
So what was the kilowatt hour for production costs? I mean,
based on the information that the company has provided, I believe that number is $1,977 per kilowatt.
Versus 1,471, which you originally estimated, correct?
Correct.
Okay, and that was pretty much due to?
There were three primary factors. I would say the first two would be delay in action on our interconnection requests by the SPP. There was a delay in action on our wetland permits by the Army Corps of Engineers. And then, of course, actions taken by governments in other parts of the world to deal with the global health emergency that resulted in delayed delivery of turbine components.
Okay, so then let me ask you this, your PPAs that are expiring, have they been a flat cost over the life of the contract?
They have not.
So when have the increases occurred that you were obligated to pay as a company?
I'm going to have to defer that to probably Witness Dole.
Okay. That's fine. I wondered if perhaps he would be the best one. All right, and I'll hold the bulk of my questions. Thank you, Mr. Chairman.
Thank you. I have no questions of this witness at this time. Accordingly, we will turn for cross-examination to Curb. Mr. Love.
Thank you, Commissioner. Mr. Rooney, my name is Todd Love. I'm attorney with Curb. I have a few questions for you if you're ready.
Yes.
Yeah. On page 3 of your direct testimony, you state that Empire performed an update to its 2016 IRP in early 2017 after being acquired by Liberty Utilities. Is that correct?
That's correct.
Am I correct that in the initial 2016 IRP, the recommendation was that Asbury would continue to operate and that new wind would not be added until the current purchase power agreements expire several years from now?
That's my recollection, yes.
Yeah. Would that possibly be in Mr. McMahon's testimony? You may not have read it, but
I have read it, but I do not recall for certain.
Okay, thank you very much. The current company currently has 2 PPAs for wind. Is that correct?
That's correct.
And those 2 wind PPAs expire in 2025 and 2028. Are you aware of that?
That is also correct.
Liberty's acquisition of Empire was completed in approximately January of 2017, correct?
Yes.
So after that acquisition, Empire reevaluated the conclusions contained in its 2016 IRP. Is that also correct?
That is also correct.
What role did the acquisition play in Empire deciding to reevaluate the 2016 IRP?
I was not directly involved in the decision to reconsider the IRP. However, you know, being part of a larger company that has experience in developing and building wind farms, as well as experience with tax equity finance, certainly opened our eyes to other possibilities than we had traditionally considered.
Were Liberty Utilities or Algonquin involved in the decision to reevaluate the conclusions contained in the 2016 IRP?
I'm not certain.
Okay, thank you. As you stated on page 4, lines 3 through 8 of your direct testimony, Empire actually acquired land rights at 2 locations, as well as several options to lease land in anticipation of these projects. Is that correct?
That's correct.
You state on page 4 of your direct testimony that Empire issued an RFP on October 18th, 2017, which was very close to the time that it filed its pre-approval application in the 18184 docket here in Kansas. Is that also correct?
Yes.
That RFP limited responses to projects that were to be owned by Empire. Is that correct?
That's also correct.
Did Empire evaluate typical PPA prices for wind at that time? And was the company generally familiar with PPA prices at the 2017-2018 timeframe?
No, and largely I think, you know, as witness Tim Wilson stated, we didn't need to. You know, we realized that we had the capability to take advantage of tax equity financing and internalize those benefits to the advantage of our customers, and without the need of, you know, unregulated third party to do that for us.
Do you know if Liberty Utilities had an objective of increasing earnings by increased investment in Empire when it purchased Empire in 2017?
I do not.
Who made the decision not to consider PPAs? Is that a group decision or an individual decision, do you recall? Or do you know?
I was not involved in that decision.
When energy is procured pursuant to a PPA, the company recovers its actual cost through the energy cost adjustment mechanism. Is that correct?
I'm not familiar with all of our cost recovery provisions in Kansas, sir.
I appreciate your honesty. Thank you. And the next question may be on the same line, and if you don't know, please feel free to tell me. And that is a recovery mechanism that provides for dollar recovery, but it doesn't result in a profit for shareholders, meaning a cost adjustment. Okay.
I'm not aware, sir.
Okay. When the company recovers its cost through traditional rate-making process, as proposed in this case, shareholders do at least have an opportunity to earn a profit or return on their investment, correct?
Yes, sir.
On page 4 of your rebuttal testimony, I believe lines 15 through 19, you discussed positions of staff and CURB regarding whether these wind projects are needed to serve Kansas customers. Is that correct?
I'm sorry, what page, sir?
I believe it's page 4 of your rebuttal testimony.
Ah, okay.
lines 15 through 19.
Correct. Okay. Yes.
Okay. And on page 5 of your rebuttal testimony, you stated that, and I quote, would like to address the need for the wind projects from a big picture perspective. Is that a correct quote?
Yes.
And further down on lines on lines 22 and 23 of your rebuttal testimony, you state that the Missouri Public Service Commission concluded, I quote, Empire's proposed acquisition of 600 megawatts of additional wind generation assets is clearly aligned with the public policy of the commission and this state. Is that correct?
Yes, that's a direct quote from the report and order issued in that case.
Okay. And what public policy were they referring
to? The public policy to expand the availability of renewable energy within the state.
Okay, moving on to page 6 of your rebuttal testimony. I believe lines 6 and 7, you state that the evidence has shown significant long-term cost benefits for Empire's customers throughout its service area, including those in Kansas. Is that correct quote?
Yes.
Okay. By evidence, are you referring to the generational fleet savings analysis or GFSA discussed by Mr. McMahon?
Yes.
Was the GFSA the primary support presented for the wind projects before the Missouri Public Service Commission? Are you aware?
In which case?
Assume the most recent case. If you don't know the answer, that's fine.
No, it's just that there were two cases. So.
Oh, okay. I'm sorry.
So yeah, the projected savings that were demonstrated by the GFSA were the primary support. They're the primary reason for these projects.
Okay. Now, and I'll have to ask commission's forbearance on this. The next question may have a confidential answer if you know the answer at all. So if it is confidential, please let us know. Did you know the estimated, or do you know the estimated cost per MWH that was reflected in the GFSH and presented to the Missouri Public Service Commission in the CCN docket where they approved the wind projects?
I do.
And Commissioner, I'm not sure how you wish to handle that. There is an amount we would like to ask for, but I believe it is still confidential since it was not included in the numbers that Mr. Flaherty and the rest of us discussed earlier.
We'll remove the confidentiality so you can discuss it publicly. Thank you.
Okay. You say you are aware of that number. Is that correct?
That's correct.
What would that number be?
Let me believe it's 2397.
Okay. I had per Mr. Mooney's testimony in Missouri, it was 2380. Would that be perhaps?
Sorry,
correct?
2380. No,
Okay.
You're correct.
Okay, thank you very much. Would you agree that that this estimate is quite a bit different from the levelized cost that's being proposed here? We're talking 2380 and 3370.
Those two numbers cannot be directly compared. I mean, they were calculated differently. The 2380 was calculated for the purposes of comparing alternative projects. That was not a number meant to set a recovery rate for the company's capital investment as well as its costs to own and operate the projects.
Thank you very much for your answer. Commissioners, I have no further questions for the gentleman.
All right, very well. Thank you, Mr. Love. Let me turn to the KCC staff for cross. Mr. Jevons, please.
Thank you, Chair. Good morning, Mr. Rooney. Thank you for your participation in the docket this morning.
Good morning. Thank you.
I'd like to direct you to your direct testimony My first set of questions relates to that direct testimony. Do you have a copy of your direct testimony with you?
I do.
Okay. On page 3, line 21, you state that Empire's 2016 IRP process determined that Empire should acquire wind generation strategically located in or near Empire's service territory rather than PPAs, correct?
That's correct.
On page 4, lines 3.
Sorry. Actually, if I could just correct that. Sorry, that was not the outcome of the 2016 IRP. That was the 2017 update to the 2016 IRP.
Okay. On page 4, lines 3 through 4, Empire's acquisition strategy identified 2 locations in southwestern Missouri, and Empire acquired the necessary land rights to develop wind generation projects at those locations, right?
Correct.
When did Empire acquire the options to lease land in southwest Missouri?
Those options would have been acquired in the options to lease would have been acquired in the spring of 2017.
Okay, thank you. On page 4, lines 11 through 12, you state in 2017, Empire retained Burns and McDonnell to assist with the development of a competitive RFP process, correct?
Correct.
So Empire acquired the land rights before the RFP process, correct?
My testimony does not contain the exact date of those 2 items relative to one another, so I can't state that definitively here today.
Okay. The RFPs were for soliciting bids to engineer, procure, construct, and transfer ownership of 800 megawatts of wind projects, right?
Yes.
And the RFP provided 2 options to developers, correct?
Correct. They had 2 options.
The first option was for developers to construct projects that they currently owned and then sell the projects to Empire after the project achieved commercial operation, correct?
Yes, sir.
The second option was for a developer to construct wind projects on the Kings Point and North Fork Ridge sites in Missouri that were being developed by Empire, correct?
That is also correct.
None of those RFPs sought wind PPAs, correct?
That is correct.
After receiving bids, Empire, with the assistance of Burns and McDonnell, determined that 20 projects conformed with these bid instructions, correct?
That is the correct number of conforming bids, yes.
In other words, only 20 projects conform to Empire's acquisition strategy of seeking ownership, right?
I would say that only 20. There were other bids that conformed with it with respect to our desire to own. There may have been other commercial aspects that disqualified them.
Okay, but the technical evaluation that Empire and Burns and McDonnell used were for these 20 projects that were ownership only, correct?
The 20 projects that submitted qualified bids complied with the RFP specification, yes.
Okay, so Kings Point, North Fork Ridge, and Yosho Ridge wind projects were not directly compared against wind PPAs, correct?
That is correct.
Mr. Rooney, on page 18 of your testimony, you discuss whether or not Empire could supply power in the event there was an outage at all 3 purchased wind projects. Isn't it true that an outage at one or even all 3 of the wind projects will not result in service interruption for the company's customers?
The failure of all 1, 2, or even all 3 wind farms simultaneously is unlikely to result in service interruption to all of Empire's customers.
Mr. Rooney, in response to questions from Commissioner Duffy, you responded that there were several unanticipated cost increases on the construction of the wind farm, those being interconnection costs, delays in permitting, et cetera. If Empire had signed a PPA in 2018, instead of deciding to construct these wind farms, would those cost increases and risks of construction been borne by the developer or by Empire?
That's not entirely clear without an actual contract. Just to be clear, the cost increase was not interconnection cost, it was failure of the transmission provider to act in a timely manner on our applications. Items such as failure to act of an agency on a permit could very well have been subject to a force majeure clause that could have turned costs for that delay back to the purchaser.
Mr. Rooney, I'll direct you to your rebuttal testimony now. You have a copy of that in front of you.
I do.
Please turn to page 3 of your testimony, lines 20 through 23. At page 3 of your rebuttal testimony, you rely upon Blake Merton's direct testimony in case number EA 2019-0010 before the Missouri Public Service Commission. On line 15 of Mr. Merton's testimony, he states that if Empire were the owner of those facilities, it could retrofit those facilities. So is Empire not seeking the cost of retrofitting the wind projects and Empire's cost recovery in this proceeding?
At this time, we are not. As Mr. Wilson stated earlier, we currently have no plans specifically to refit any of these facilities. We certainly have that option over time, but one of the advantages of owning this wind farm for 30 years is that we have time to see how technology develops and what other benefits may be available to our customers.
Okay, so Empire may pursue a retrofit of one or more of the wind projects, right?
It's within the realm of possibility. It depends on whether those things pencil out to the benefit of our customers.
On lines 15 to 17 of page 18 in Mr. Merton's testimony, he states that by retrofitting the wind farms, Empire could make them more efficient for customers, get more energy out of them, and have lower operation and maintenance cost. Does Empire anticipate a future retrofit of the wind projects would provide net benefits to ratepayers?
I mean, I'd have to speculate on that, but history to date has shown that some wind farms do benefit from repowering at some period in their life.
So any net benefit from a potential future retrofit is unknown at this point. Correct.
Yes, I mean you're talking about the continuing development of technology. Yeah, it's unknown at this time.
Mr. Merton's testimony states that a reason ownership is preferable is because of Algonquin Power and Utilities Corporation's expertise in owning and managing wind farms and its expertise developing opportunities with tax equity partners. Here, that expertise did not end up with Empire constructing a wind farm at an installed cost less than the average cost, right?
I'm not sure what the average cost is, sir.
Thank you, Mr. Rooney. At this time, I do not have any further questions.
Thank you, Mr. Jennings. Follow-up questions from commissioners. Commissioner French?
Well, I'm trying to decide. You may not be the right witness for some of these questions. They may be better directed to Mr. Dahl, but let me go ahead and ask on this concept of, I guess I'm looking at page 3 of your direct testimony. where you sort of set up the fact that, and I'm specifically at line 19, page 3, line 19, you say the company determined based on this analysis, it could deliver long-term savings to customers by acquiring wind generation strategically located in or near the Empire service territory that would not require the construction of any significant new transmission facilities. And I guess what I'm wanting to do with you or someone else is to dig down a little bit on what exactly the strategic advantages were to customers of building wind in or near the Empire service territory, rather than acquiring maybe a lower cost resource that necessarily is going to be located farther away. Is that partially related to, I suppose that strategic advantage is partially related to the revenue that you would receive in or near the Empire area being higher, correct? So any revenue that you're able to produce out of these wind farms is going to be higher if you're selling it at that location, correct?
Correct. Yeah,
So
that's absolutely right.
And the other piece, and this, I know this is something Mr. Dahl knows about, but if you could help me, is it possible to quantify or create a comparison of acquiring, say, a PPA of wind in Western Kansas, which is obviously going to be at a lower cost? What is the cost of delivering that to your customers, or getting a congestion hedge to compensate your customers to assure that they receive the value of that? I guess how in my mind do I think of the cost benefit? What was the trade-off when you talk about either acquiring the wind in your location versus considering acquiring it, build or PPA, farther away, and then having to deliver it? I mean, what were the considerations there?
Sure. So some of that you'll find in the section on the RFP evaluation. So of course we looked at LCOE for projects. Then this issue we've discussed regarding revenues, we did a evaluation of each of those projects. We had them provide a proxy node, did some generation weighted LMP, came up with a yearly LMP differential between their node at which they were going to sell energy versus what we would be buying for at Empire's load node. So, that made up some of that, basically because the LMPs have a locational, obviously location is a factor in that, but that was included there. We also, I think this came up in Tim Wilson's testimony earlier. We factored in the most recent 3 years of these LMP differentials, basis differentials, and then we projected 2 future years. It was then a future year. It's now a past year, 2020 and 2025. And using the standard deviations of those annual LMPs to assign some measure of variability in the transmission risk in the future to evaluate the projects.
I think I'm going to ask Mr. Dahl, maybe Mr. McMahon, about that, because that's something that the transmission piece is what's not completely clear to me. I understand that the ability to earn higher revenues if it's located, but I'm not quite getting what the evaluation was or exactly what the higher cost is if you had acquired wind from maybe a more optimal source and having it delivered. So I may ask Mr. Dahl about that. But I do want to talk quickly about the piece on the higher revenues. I mean, I indicated earlier, I think it's fair to factor in the opportunity for revenues. But one comparison I made is, I think when we were looking at the example of Western Plains, we were talking about maybe $20 of avoided production costs and $4 of potential revenue per megawatt hour. Where here we're talking about maybe $20 of avoided production costs and $18 of revenue. While that presents a potential value or opportunity to customers, would you agree that these projects, because they are so reliant on that revenue opportunity, that also presents a much bigger risk than the example of the Western Plains wind farm? And if that's a better question,
I would contend that all projects are reliant on their revenues, and that's why we, have such a concern with the fact that they seem to have been neglected.
Thank you. I think that's all I have. Thank you, Chair King.
Thank you, Commissioner French. Commissioner Duffy?
Okay, so I always have heard if it's too good to be true, maybe it's not quite true. And so it sounds like, I mean, as you look at the revenues that are proposed, that, whoa, okay. It's like we're in the business and there's going to be a chicken in every pot. So, but let me go back to your qualifications at the beginning. I'm on page 2 of your direct testimony.
Mm-hmm.
You talk about, like in line 13, you were the manager of strategic projects. On to 15, you were to set goals that aligned with the company's goals and to lead all plant operations to achieve these goals. Then in 2018, I'm on line 18, you assumed the position of generation operation project manager, where your responsibilities were the same as when I'd been manager of strategic projects, which I assume that includes setting goals that align with the company's goals.
That's correct.
So, not unusual, but okay. So you made a statement that you didn't need to look at PPAs. You did not need to. Yet, if I read from Kane and Puga's testimony, I'm like on page 17, they just say down at the bottom, the exclusion of the PPAs prevented a transparent evaluation that would support resource selection and validate whether the cost of utility-owned wind is efficient or just unreasonable. In absence of this critical information, the RFP implementation and Empire's evaluation and selection of projects are insufficient to support the conclusion that the costs Empire would impose on Kansas ratepayers and resulting rates would be just and reasonable. So Burns and McDonald, they come in. Did they suggest that perhaps you include PPAs as part of your evaluation process?
No, they did not.
And you, as a group, summarily dismissed that possibility as not that you didn't need to do it. But it's not, you didn't need to, well, maybe it is, but should you have done it to eliminate any question about your ultimate course of action? I just find that if your parent company is such an expert at this, why wouldn't they have just gone through that process as well and tell Burns McDonald, and by the way, let's evaluate this and let's get an RFP out there to for comparison purposes.
I'm sorry, what was the question exactly?
Well, it just, if you all are the expert on wind management, you really believed you didn't need to evaluate PPAs. Is that correct?
We believe that we could achieve the same objectives by internalizing the tax equity benefit, and that at the same time to evaluate PPAs would have been duplicative of the efforts we were undergoing in soliciting RFPs for build own transfer agreements.
Okay, so by the same objectives, does that also include shareholder stake as well? Shareholder value? Was the objective the same? Build versus PPA? So are those equal with whatever choice?
The objective was to deliver the customer savings that were demonstrated in the generation fleet savings analysis.
Will shareholders benefit from this choice?
Will shareholders benefit from this choice as opposed?
Will shareholders benefit from Empire building the wind farms as opposed to continuing with a PPA arrangement?
I'm not sure what the relative shareholder benefit is of those two.
Okay. All right. So is it true that your parent company was involved in the decision or not? I'm unclear as to who actually, did they participate in the ultimate decision to build these plants?
I'm not sure who the actual ultimate decision maker was. I joined this team after the decision was made.
In your role, in your present role?
In my present role, yes.
Okay. All right, well, maybe this will be a better question for somebody else who was there at the time. Okay. Mr. Chairman, I think those are all the questions I have. Thank you.
All right, very good. Mr. Rooney, I'm going to ask a question you've been asked previously, I think by both commissioners, but I'm going to ask it in just a little bit different way to try to flesh this out. I'll just do it in my own way here, and you respond as best you can. My question is, it's a follow-on actually. Why didn't the company take into consideration the opportunity cost of not pursuing or considering the PPA approach in lieu of the construction and ownership approach?
As I stated previously, we did consider, whether or not a PPA should be an option. On that consideration, we determined that we were capable of achieving the same objectives by internalizing the benefits of tax equity and delivering those instead to our customers directly, rather than relying on another party to do so.
Okay. So I'm not trying to put words in your mouth. I'm just trying to understand how, I guess, by what method you considered the trade-off. That's what I'm really asking here. And I kind of, the essence of what I take away from what you're saying is that there was consideration given to this, but it was done in a more informal way. It wasn't done in some really terribly formal way that developed an extensive paper trail that would make that comparison, but that you somewhat used your intuitive skills, and I'm not suggesting that isn't substantial, to make the determination that it was better to go with the approach you took than the PPA.
I think that is a correct way you could state it. I mean, some of the benefits that are out there. I mean, Tim Wilson discussed some of them this morning. The value of having an interconnection available out into the future, so that we can deploy other technologies. We can co-generate at that site. We can utilize storage. Items like that are not available to us, and the flexibility that it gives us to pivot as we need to deliver benefits to our customers in the future, if we don't own those projects.
Very well. I appreciate the candor of your response. All right. Mr. Flaherty, I want to give you the opportunity for redirect to be sure, but let me kind of cover the territory here, maybe more expeditiously. I'm going to turn back to, with your indulgence, I appreciate that. Let me turn back to Curb. Mr. Love, do you have any recross?
No, sir.
KCC staff, any recross?
No recross for KCC staff.
Very well. Commissioner Duffy.
Yeah, can I just ask, in your present contracts with your PPAs, have you had problems, issues, concerns throughout the life of the contract?
Are you looking for any specific type of concerns, or?
I don't know. I mean, when you've got a contract to deliver so much power, I think you Storm Uri, it's not clear if they have a winter package on and we're able to continue, and maybe you can answer that question, providing power. But outside that, have there been negative issues with the PPA? Just asking generally.
Sure. Yeah. To be honest with you, Aaron Dole would be a more appropriate witness for that. He oversees the scheduling and sales of our energy.
Okay. Do you know about the winterization?
On their projects or ours?
Yeah, their projects.
I do not. I am not aware of whether they have it or not. If there had been some time between me and Mr. Wilson, I would have tried to have an answer for you right now. So
okay. We'll hope that Mr. Dahl will be able to answer. All right. Thank you. Thank you, Chair Keen.
Thank you. Mr. Flaherty, redirect.
May I ask one more question before we let Mr. Flaherty go? I promise it'll be quick. Is that okay, Chair Keen?
Yeah, absolutely. Please go ahead.
This is just one of me trying to get my head around it and make sure I'm thinking of this in the right way. I think the question of PPA versus ownership is interesting, but I think you can tell to me it's at least as interesting the question of location of the projects. And am I thinking of it right to say that the decision to locate the projects in the Empire Territory, that was what caused the cost of the projects to be so much higher and the opportunity for larger revenues to be so much higher? Is that Is that a fair way of thinking of it?
I'm sorry, when you refer to the higher cost, which measure are we using here?
Well, if we were just to compare, for instance, the $33 figure to say the $20 figure of something like the Western Plains wind farm,
Right.
the levelized cost of energy of these wind farms versus those. But then obviously the opportunity of higher revenues in the location you're located at. Is it fair to say that, you know, being a less optimal location for wind and maybe other reasons is what causes the cost of the levelized cost of energy of these projects to be higher, but also causes the revenue opportunity to be higher? I guess I'm just asking if those are a function of the location.
Yes, I mean the higher price on the the levelized cost, the higher levelized cost is a function of the higher revenues. It reflects the additional value that those revenues provide. I mean, we have to buy energy in a high cost area to deliver to our customers. Having our generators selling at a node that's adjacent or nearby means, because the price is locational, that there should be similar prices barring abnormalities in transmission. Also less risk of congestion. We're using a limited number of facilities to deliver it to our load, so that there's fewer users there when it comes to transmission rights, all things that Witness Dole will be able to speak
and
with
maybe
more
I
specificity too.
need to ask him this, but is that also a function of where these projects are located? You would expect relatively lower output from those facilities than, say, the Western Plains wind farm?
I would expect there to be some difference in capacity factor, but there's a number of things that can influence that. Turbine hub heights, rotor diameters, then of course, obviously the big ones, the wind resource available. So that's one of the difficulties we have in establishing how can you compare, say, a Neosho Ridge to a Western Plains. It's just that there's too many factors to consider that.
I think the thing I'm struggling with is this concept of the price is higher because the value is greater. That doesn't really make sense to me in the public utility context of cost-based rates. I know there's something I'm missing there. That the idea that customers don't necessarily pay for value, they pay for the cost. I guess that's what I need a little bit of clarification of. Why is that a relevant value for consideration in rates? And feel free to say that should be deferred to someone else.
Oh, no. I mean, the customer's cost of fuel and energy is it's a net cost. Those revenues are the other side of that ledger, their energy costs.
Okay, I think that's all I have at this time. Thank you.
Okay, so the value is what? The increased value is really what? I mean, if I'm buying milk and I've decided to buy a cow to get milk, Holstein, Guernsey, am I going to buy which one am I going to buy, and where is it being grazed? I mean, that's pretty easy. But if you look at the wind map, the resources aren't the best where these are located out west. Woo, hot dog. But so it is define value.
because the prices we receive for the sales of that energy are similar to the prices that we pay to purchase the energy that we deliver to our customers. So those revenues net our purchases.
Okay, all right. So compared to your present, like your PPAs right now. But to Commissioner French's question, why didn't you did you look out west? Were any of the bids that came in from folks way out west?
Yeah, we had, let me look at the project list here. I know that there was Chilocco, which was one that was considered to very late in the process, which was out in kind of, what would that be? North central, maybe even northwest Oklahoma. Sorry, here I'm flipping through the exhibits that have the actual locations.
Oh, I've got it. But you had already purchased the option on that land, right?
We had an option to lease the land.
An option
yes.
to lease. Let me get that right.
Correct. Yeah, a relatively small commitment.
How many
There's
acres total were we looking at?
Oh gosh.
Would Dahl know?
No, probably not off the top of his head. It's a number I can put my finger on, but I just don't have it available right here in front of me. It was
That's all right.
in the tens of thousands of acres.
Okay. All right. Thank you, Mr. Chairman.
All right, Mr. Flaherty, redirect.
Yes, thank you, Your Honor. And Mr. Dalma, he probably should get a good lunch in because it sounds like he's going to get a lot of questions this afternoon. So let me start with, do you recall Commissioner French asking a question about the fact that we're talking about values and then, but that commission sets rates based on cost of service? Do you recall that question?
I do.
Yeah, and just so the record's clear, Empire's that what it's trying to recover as far as it relates to its wind farms is what it like it would in any other generator. Its actual cost, its O&M cost, its return, its taxes, and so that's what we're trying to recover in rates, and that's what's reflected in the rate application. Correct?
Yes, that's absolutely correct.
Okay, so we're not going on the internet and saying, well, these wind farms are worth 1.5 billion, and so we're asking for 1.5 billion. We actually have actual capital cost, actual O&M cost to support what we're asking for. Correct?
Yes, that is correct.
Okay, and Commissioner Keene asked you a question, and I think all three commissioners did, like he said, about, why didn't Empire just go out and solicit RFP for PPAs? And let me ask you this and see if maybe this might help. And let's use Neosho Ridge wind farm that you acquired. You're familiar with Neosho Ridge wind farm?
Yes, I am.
And that was developed by Apex, correct?
Apex.
So
yes.
If Apex was going to basically give Empire a PPA instead of what I think is referred to as a BOT offer, is it your testimony that those would have been similar in nature because of the way Empire was, like you said?
Objection. Empire's counsel is leading the witness.
Now, let me rephrase the question. I was sorry. So if you take a look at Neosho Ridge, would the market developer had provide you a different rate for a PPA versus ownership, in your opinion?
On the basis of the levelized cost?
Yes.
No.
So why do you say he would have given that? You, in essence, what you're saying is he would have given you about what you determined the cost was. Is that right?
Right. It would have essentially cost us the same to construct the project or cost them the same to construct the project. The tax equity of finance would have been available to them as well. I see no reason to expect that a PPA price would differ in any way from the levelized cost approach.
Okay. Mr. Love and Commissioner Duffy asked you some questions about, I guess one of the differences between ownership and a PPA is that under ownership, the return on the investment of the wind farms goes to the shareholders, but under a PPA, where does the return on the investment go there?
Well, the return on the investment goes to the shareholders of the developer or the operator of the wind farm.
And so the customers end up paying the return on the investment, whether it's to the company through rates or through this unregulated third party, correct?
They pay a return on that investment to somebody, yes.
Yeah, and that's because it's the developer builds that into the, or should, if he's a good developer, builds it into his PPA price, correct?
I don't know of any seller that sells at cost.
Okay. And Mr. Love asked you some questions regarding the I guess the megawatt hour price that was in the GFSA, which I think he said, Mr. Mooney said was $23.80 a megawatt hour. And you indicated to him that's not the same way in which you would calculate an LCOE for like a fixed price purchase agreement. Can you explain why that's the case? Why they're different?
Yeah, and it's actually laid out pretty well in the testimony of Mr. Crane and Mr. Puga on page 21. Essentially, when we calculate an LCOE, generally what you would do is you sum up the costs of your capital costs and your operating costs over time of an asset and divide that by the expected revenues. And in doing so, you also discount both the numerator and the denominator of that number. In the case of the GFSA, the expected production was not discounted. So we discounted the numerator and not the denominator. There were also a few other changes that led to differences in those numbers. I think there was a change in interest rates, the debt to equity ratio of the company, change in income tax rate, a reduction in O&M estimates, and there were one or two other factors that I don't recall.
If the way the LCOE was calculated in the GFSA, which was $23.80 per megawatt hour, and you were trying to get a apples to apples comparison of that number with what let's say the $33 number, do you know what that apples to apples number would be for the GFSA number?
Sure. So if we just took the GFSA number and discounted the denominator by the same factor we discounted the numerator, it comes out to roughly $30. However, that was discounted with a 2% factor for inflation rather than the company's weighted average cost of capital, which is what gets us from the $30 to the $33.73.
Thank you. That's all I have. Thank you, Mr. Rooney.
Right. Thank you very much. Mr. Rooney, I believe we've come to the end of your testimony. At this time, I will thank you for your testimony. You may virtually step down and you're excused.
Thank you.
Thank you as well. We are now 2 hours since the last break, and we're well into what we might consider as the next break, which I'm going to call lunch. We'll take at this time, I think in the interest of time, given the number of witnesses we have and the likely testimony, it's customary for us to take 30-minute lunch breaks, and that's exactly what I intend to do here. By my reckoning, it is more or less 12:45 when we plan to resume at 1:15. And we'll resume with the next witness. We're going to take a recess now, and we're off the record. Thank you.
Thank you.
Michelle, are you there? Michelle? I see you, Todd. I don't hear Michelle.
I see you as well, and I see a big blank screen of blue.
We've got a
and
blue screen of death.
Using up for lunchtime there.
I was starting to worry I had somehow left the conference without realizing it.
Good afternoon. Michelle is not at her desk, but I could, I think I can take control and take the slide down if you're ready to begin.
Thank you, Denise. I think we are ready to begin. Let's
Okay.
see what kind of a role we have when we do that.
Let's see if I can do that. I think I will probably have to share a different slide first in order to do that, but I can do that.
Sure, thank you.
Hey, Michelle, there.
All right. The gathering of the troops here. It's amazing how short a half hour can be, isn't it? It really is. Naola, are you there?
I'm here.
All right. Our apologies for making 2 hours out of that last interval here. That was a long time for you, I know. We'll try to be a little more cognizant of that this afternoon, and maybe take more frequent and short breaks. So it has to give you a break as well. Let's do some housekeeping. Take care of the housekeeping issues here. Mr. Flaherty, when we were talking about the order of witnesses and all, especially the Empire witnesses, I neglected to ask about the availability of Mr. Tillman. Is he available tomorrow?
He is, yes.
So all of your witnesses are available tomorrow.
Yes.
Okay. Well, we're going to move on. We're going to move as far as we can today. Todd, I would say this insofar as I don't see Andrea's name up there, but she's probably with us. But
she is, Commissioner. She's watching by YouTube until she needs to sign in by Zoom. So
okay, I would just
probably listening now.
Okay, I just give her a heads up that we will certainly get her in tomorrow. My goal would be to even perhaps tomorrow morning, so that she can go on about other things and has some certainty about that. It's quite conceivable, depending upon how much time these witnesses take, that she could be the last witness today. Let's just see how that plays out. I do believe, in the interest of certainty for everybody here, my goal would be that we conclude today's activities one way or another by 5:30, and we call it a day. To resume tomorrow at 9. Does that sound acceptable to all parties? All right, Commissioner Duffy, is that acceptable to you?
Yes, like walking out the door at 5:30, if possible. If not, I just need to know that.
Well, that's fine. We'll try to heed that admonition. Believe me, we'll somehow we will try to do that. Commissioner French, is that acceptable to you? Okay, very good. Okay, Naola, we are back on the record. Let's go back on the record now. It is approximately 1:18 p.m. on Tuesday, March 18th. We're going to resume with the examination of witnesses. So I would again turn to you, Mr. Flaherty, and ask that you call your next witness.
Thank you, Your Honor. Empire would call Mr. Drew Landau.
Mr. Landau, I need to swear you in. If you'd raise your right hand. You solemnly swear the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth.
I do.
Can you state your name and business address?
Drew Landau, 602 South Joplin Avenue, Joplin, Missouri.
By whom are you employed?
Liberty Utility Service Corp.
What is your, what is your position with utilities, Liberty Utility Service Corp?
Director of Strategic Projects for the Central Region.
Okay. In that capacity, did you submit pre-filed direct testimony on behalf of the Empire District Electric Company in this docket?
Yes.
Do you have any changes or corrections to your pre-filed direct testimony?
No.
If I were to ask you the questions that are set forth in your pre-filed direct testimony, would your answers be the same today?
Yes.
Mr. Chairman, I would request that Mr. Landau's testimony be referred into the record.
Chair, you're muted.
Let's try that once again. Is there any objection? Without objection, it's admitted. Sorry about that.
Thank you. I would tender Mr. Landau for questioning.
All right, very well. Again, I'm going to begin with the commissioner questions. We'll see if there are any to start this off. This time I will begin with Commissioner Duffy.
Thank you. Good afternoon, Mr. Landau.
Good afternoon.
Landau. I'm going to go completely different direction here. So in your testimony, I believe, and I'm not sure the page, you discussed that 1.7 million is needed to put in new utilities as demolition occurs at the remaining portion of your site. Could you explain that a little bit more?
Yes. The site was developed around the power plant, from 1970 and beyond. So most of the infrastructure was built to support the plant. And then as we grew it throughout the next 50 years, we added things on. And for instance, we pulled the power out of Unit 2, which was the old steam turbine that is now it has been removed. It pulled power and repowered the new office that was built in 2012, 2013. That's one example. So as we go forward and Asbury Unit 1 and all of the infrastructure with that is removed from service, we have to redo our utilities. So we're going to tap back into our existing substation, put a new set of switchgear in, and bring new distribution power out to the facilities that will remain. So that's bringing new power into the big new shop that we built, the existing office building, and then also adding new water suppression or fire suppression or water lines. So those would be new pieces of equipment to keep those facilities running.
Okay, so a new shop was built. I just had the I guess the idea that the Asbury Renewable Operations Center was just a collection of existing facilities.
I refer to it as new because it was built in the 12-13 timeframe compared to the rest of the site. And that is what is being utilized for our wind farms.
Okay, and so even though at one point it housed 60 some employees and you're down to under 30, you still need all the facilities there that you've identified in the map?
Yep, we utilize all of those facilities. That was one of the benefits of locating our main operations center at Asbury. Was that very large shop existed. It was able to support all of the needs that Vestas required for their maintenance and service agreement. So we didn't have to build a new shop. We didn't have to build 3 very large inventory centers for each one of our facilities. We co-located that Asbury central between all 3 farms.
Okay, and I guess it is now, you believe those assets are valued at 15.5 million?
Yes.
Hot dog, I was kind of surprised by that.
Well, that also includes all the land, the infrastructure built up around it, the shop. Like I said, the shop is new. There's still a rail loop that's in service. It's not just those 3 facilities, those 3 buildings. It is everything that is still there, in active, in service, and used and useful.
Okay, so, and the demolishing unit 1 is estimated to cost, is that correct, $36.4 million?
I think 36.9.
36.9, I'm sorry, can't read my own writing.
Yep.
Okay.
And at the time that the testimony was prepared, that is correct.
And so do you believe you'll be able to stick to $36.9 million in demolition costs?
We have been, as we put in there, we're working on this. We have been working on this. My testimony was filed in May.
Right.
We have been working with our consultant, Black and Veatch, and we have had another round of estimates put together. We were able to go from the conservative estimate that put the 36.9. We really did some on-site scoping, really identifying the asbestos, the hazardous chemicals, all of the other things that are a big risk when you're doing these, and spent some time to bring that estimate down. We're going to allow blasting in our estimate. The first was we'll call it a surgical removal, but blasting is much more efficient. And it's what we did at Riverton 7, 8, and 9. So the good news is, the punchline is we're looking at an estimate around 15 million at this point. That could be further offset by changes in commodity pricing. We've got a bunch of steel, copper, aluminum, and other very valuable assets for salvage out there.
Okay. But if you had abandoned in place, the estimate was 5.7 million. And that would include making it safe to abandon in place by putting up fencing or whatever you would require.
That is
and
correct.
Extracting those things that you absolutely have to. Or
correct.
Okay. And the company has determined the best thing is to demolish the unit.
That is correct. The 5.9 million estimate that was put in there was roughly a 10-year estimate to keep the facility there, remove items that were of immediate concern. The old stack, the original 1970s stack, isn't going to last too much longer. It's got a brick liner. So it's one of the concerns that we're afraid will not make it 10 more years. So that's in that 5.9 million. So that's to make the facility safe, because we still are there. Our people are there.
And I understand that. So along that line, you're going right to where I was headed. Do you have somebody telling you you need to do this, that to ensure safety, that stack, I mean, is that somebody who's an expert? Has somebody actually told
Yes.
you that in 10 years that could begin to fall apart?
That is correct. We have had our stack inspector out to do it. We've done a specific inspection to give us an estimate on how much longer we can let that stand. And we've done that over the last year as well.
Okay. And finally, you're spending $4.4 million in this planning of the demolition and the environs, right?
That also includes some removal of CCR and NPDS improvements. There are certain things that we need to do to currently comply with our permits that are still out there. So we had to do some modifications to the NPDS permit when we removed all of the coal pile. We have been working on some removals of all of the anhydrous ammonia. That was something that we removed that came with an expense, but that got rid of our EPA compliance, and we don't have to have a hazardous waste response team on site. So there's some savings that happen there. We've been removing and cleaning up many items that are just lab reagents. The place has been in operations for 50 years, and We're working hard to remove some of that and, like you said, develop plans, specifications, bid packages, and scheduling. With
Okay.
Black and Beach being our lead engineer on that.
Thank you. And finally, my last question is this Asbury Renewable Operations Center, you predict that you will be in this facility for 20 years?
I believe the lease on our wind farms is 30 years with an option to go 30 more. So that would be how far, that is where our control room and our operations sit for those 3 facilities. We also added a community solar facility a year or 2 ago. It is operated from this facility as well. As we go forward in our IRP planning, we fully anticipate to see additional solar coming in as our 19 IRP showed, and we will operate those from this facility as well.
Okay. And since you're the strategic officer, so in terms of storage, also that was mentioned earlier this morning that you're also looking at the possibility of what storage might take 1 acre or so, and it can be accomplished on present facility.
Yes, we've been having a lot of fun using this facility as a, kind of a trying to figure out what can we do for this to tell the story of, we got an old coal plant from 1970. It served our customers well. Now we've got a new wind farm. We've got a new interconnection that we have complete control of. And SPP's got new rules out there that allow for that excess capacity of our interconnection to be utilized. And since the substation with the ring bus where it ties in on, that's the point of interconnect for us. So there's all kinds of fun opportunities for the guys that get into developing these energy strategies to deploy batteries, put a solar farm out there, and we're able to tap into our existing transmission infrastructure with little to no cost because we can use the GI that exists for those. And we're doing the same thing for the Kings Point because that's co-located at our Energy Center plant. So there's a lot of fun that we're having in the Strategic Projects Department looking into that, but still following the IRP rules and our capacity build-out requirements.
Okay, thank you very much. And thank you, Mr. Chair. Those are all my questions.
Thank you, Commissioner Duffy. Commissioner French.
I have no questions at this time for Mr. Landell. Any questions I'd have would be based on cross. Thanks.
Okay, very well. I'm in the same circumstance, Mr. Landell. I too would defer at this point to a later time. We'll see how your cross-examination proceeds. Let's move on to cross-examination by Curb. Mr. Love.
Curb has no questions for the gentleman.
All right. Cross-examination, KCC staff.
KCC staff has no cross for Mr. Landau.
All right. One last bite of the apple, Commissioner French. All right, same for me.
Since there was no cross, I have nothing based on cross.
Mr. Flaherty, redirect.
No redirect questions, thank you.
All right. Mr. Landau, you're getting off easy in comparison, are you not?
I am. I appreciate the time, everybody.
Well, we appreciate your being here and your testimony as well. You may step down virtually and you are excused. Thank you much.
Thank you.
All right. Moving on. Again, Mr. Flaherty, if you would, please call your next witness.
Yes, thank you, Your Honor. Empire would call Mr. Aaron Dahl.
Mr. Dahl, I need to swear you in if you'd raise your right hand. Do you solemnly swear the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
Can you please state your name and business address?
My name is Aaron Dole. My business address is 602 South Joplin Avenue, Joplin, Missouri, 64801.
All right, whom are you employed?
Liberty Utilities Services Corp.
What is your position with that company?
My current title is Senior Director of Energy Strategy.
In that capacity, did you submit pre-filed direct testimony on behalf of the Empire District Electric Company in this docket?
I did.
And do you have any changes or corrections to your pre-filed direct testimony?
Not at this time.
If I were to ask you the questions that are set forth in that pre-filed direct testimony, would your answers be the same today?
I have 1 more year of service than when I filed that testimony.
Okay. Other than that, would your answers be the same?
Yes, sir.
Yeah, it's been a long year, right?
I hit the 15-year mark, so.
All right, congratulations. So, hey, I would request that Mr. Dahl's testimony be referred into the record.
Is there any objection? Without objection, it's submitted to the record.
And I would tender Mr. Dahl for questioning.
All right, very well. Good afternoon, Mr. Dahl.
Good afternoon.
Do you sense that your name has been dropped in your absence?
That's the rumor.
It's your fate today, is it not? Okay, very well. Let's again begin with Commissioner questions. This time I would start with Commissioner French.
Morning, Mr. Dole.
How are you doing?
I think I'm going to mostly reserve until after hearing whatever cross there is for you. But I do want to, I understand you're Senior Director of Energy Strategy. So I think you're our guy for understanding how some of these transactions occur and what the economics of these energy sales are. So I guess I want to understand from your perspective some of the same things I asked before, which was what are, from your perspective, what are the overall advantages or disadvantages of locating energy nearer to your load? What costs are you maybe increasing, and what costs are you decreasing by doing that?
Okay. Let me kind of make sure that we're all on the same page as far as understanding how kind of the SPP integrated marketplace work. And I understand, Commissioner French, I know you're very familiar with this, but Commissioner Duffy and Chairman Keene, just some kind of background. The simplest way to think about, just from an energy sales perspective, you'll hear SPP say the word adjusted production costs. And it's not very dissimilar from what you have in your ECA. So adjusted production costs is production costs, right? Which is kind of commensurate with your fuel or fuel costs, plus your purchases, which is what you purchase to serve your native load, which is completely separate from what you generate, minus sales or minus OSSR. So there's kind of some parallels as I was reviewing the ECA tariff. Adjusted production costs, ECA, very similar. Fuel plus purchase power minus off-system sales revenue. Okay, so getting into the meat of the question, I think we can all agree the fuel cost of wind is zero. So we can just zero that out of the equation. The purchase power cost is the cost to purchase power to serve our native load. Since March 1st of 2014, we've been in the SPP integrated marketplace. We do not self-serve load. We buy all the generation needed to serve our load separately, and then we offer all generation that we have into the marketplace for potential revenue. And those dollars, any dollars that you obtain from the SPPIM net of fuel, get funneled back to the customers through, in Kansas, the ECA. And so really, when we think about these particular wind farms, we've got the fuel cost at zero. My purchase power costs, as I know Commissioner French knows this well, but it's been intimated throughout this whole presentation. We are on a very high price load node. We're in the southwest corner of Missouri, and to be honest, if you look at kind of SPP, it's always been difficult to get transmission seams projects across the board. So Southwest Missouri has had this issue for 12 years. They will probably continue to have this issue for a while. Transmission expansion doesn't happen overnight. There are some projects that may help mitigate it at times. But we're even seeing some of these congestion pockets load up in the northeast the northwest part of Missouri up in the Kansas City area too. So that's kind of the borderline for SPP on the Missouri side would be Evergy up north and us and city utilities down south. And those are some of the higher priced nodes. Ours has been higher priced for a while. So I've got the purchases as high price. Let's say average dollar LMP somewhere between $25 and $30. I think that's a reasonable number for what our LMP is. And so the question really, I think that Commissioner French is asking is, what are the advantages of that final figure, the minus off-system sales revenue in the ECA or minus sales and adjusted production costs? It's what I can sell the power for. So if I'm buying power for $25 to $30 and I can sell that same power for somewhere around that same cost, I'm netting that out. I'm making at a $0 fuel cost, I'm making $25 to $30. If I am selling that power and it is located in a completely different node far away, I am subject to whatever price is in that node. And in particular, I know we've had some discussions about Western Kansas and there's terrific wind out there, but that is some of the lowest LMP zones in the SPP area just because of the proliferation of wind. It is a high concentrated wind area, but there's also plenty of wind farms out there. So the supply has driven down the LMPs, and we saw value in taking a diverse fleet of wind resources, putting one just western, kind of contiguous to our area, one almost dead center in our settlement area, and then one on the east side of our area. So we have some geographic diversity, but we also have mitigation for any kind of what I'll call basis differential, the difference between what I'm paying for purchase power versus what I'm selling. And I hope, if this doesn't work, I was trying to figure out another analogy. I know Commissioner Duffy, I had to Google what a Guernsey cow was because I'm not familiar with that. So I was trying to come up with something on the side. I can take a crack at that later, but
I think this is helpful. Maybe one follow-up to that. I think you've explained the economics of what the value proposition is to build wind generation in your area based on the higher price you could sell it at. Maybe give me an explanation of why are all the developers continuing to build out in Western Kansas then? Is it just because their production is higher and their production tax credit is based on how much production they can get out of their wind farm? Or why is the development still occurring out there?
So if you keep in mind, I'm going to have to surmise why I think that they build out there rather than no, I don't know a bunch of developers and they don't secretly tell me why they're building. But yeah, if you're building and your thesis is to maximize production tax credits, and maybe it's really irrespective of the revenue because your client is somebody that's really just trying to, obtain either RECs or to try to minimize their taxable income, then that probably makes sense. When you move it further east into our area where we don't have as quite a high of wind profile, you do have to spend a little bit more in capital costs. I think Mr. Rooney kind of was describing, land costs a little bit higher. You have to spread out your turbines a little bit more. You have to go to a higher hub height to be able to hit similar capacity factors. And so, yes, you do have a little bit higher capital costs to bring it closer to load, but we saw more than an offset in being able to hedge our pricing risk that we've been subject to for some time now.
I know you made reference to some of the transmission that's being considered right now, and you probably heard me ask the question earlier. We have a rather large scale project in the Wolf Creek to Blackberry line that's going to run from Wolf Creek, Burlington, Kansas, directly to your Asbury plant, right around there within a couple miles. I assume that is going to relieve congestion and to some degree lower the LMP. How do you expect that and potential future projects to affect the value proposition of Empire's wind farms to customers, the value that they would receive from their off-system sales, or well, from their sales. As you said, everything's bid into the market.
Sure. And trust me, as soon as you said that earlier, I knew exactly where you're going. Wolf Creek to Blackberry. So tying in, you're right. It's right at the Blackberry sub, which is very close to our Asbury facility. And then that will go ahead and tie east over to Morgan and into ACI's territory. And I can't sit here and tell you that that's not going to have any impact on LMPs, because I don't think that's fair. I think it will have some impact on LMPs. I don't think we're going to drop anywhere near a Western Kansas level of LMPs where the wind farm is just considerably outpacing the transmission investment. You know, I believe the latest date on the Wolf Creek to Blackberry is somewhere in the 2025 and maybe October 2025, based on the presentation that was given recently. And we'll see how, you know, I know it's an Order 1000 project, and we'll see if it's completely done on time. But you know, knowing that there could always be transmission expansion. You know, we saw this up in Kansas City when the market went live. There was an Iatan to Nashua 345 line that came in and started to cure congestion. I'm sure you kind of remember that. Balanced portfolio transfers, everybody's favorite word. And you know, it helped for a while, but again, it's being on the seam. And as you know, from what you're seeing out of Kansas City right now with, I think it's the JTIQ projects, they've got congestion up there again. It's very difficult when you've got the amount of low cost energy we do in SPP to be able to get, you know, different RTOs or different cooperatives to agree on how to expand transmission, how to pay for it, how to get everything done. So while I think you could see some projects, we've been at this for a while now. We've been an active participant in it. We've kind of changed our tone on how we vote on ITPs, just because we're really have to monitor. You know, our load LMPs have been considerably higher than everybody else's, and that's reflected in our votes in the SPP. And so we just saw this as a great opportunity to kind of hedge the LMPs, and we felt, you know, some of these ancillary benefits that, to be quite honest, are not so ancillary anymore. When you talk about owning 3 generation interconnections, either in your service territory or near your service territory, with intermittent resources and your ability to co-locate, to do surplus supply transactions there, to do generator replacement. Those are tremendous assets. And we're seeing that show up as big cost savings in our integrated resource plan, that we can't just generically retire assets and put new assets in. We have to bake in what is a considerable, not just project time in the SPP queue, because I do think they'll get that figured out, but considerable cost, right? We're going to pivot to renewable energy. It's going to take more interconnections than a lot of traditional thermal. And so that's going to put a strain on interconnections. And the fact that we have 3 very close or inside our service territory is a tremendous asset. And we see that kind of in a 30 to 20 to 30 year planning horizon. Those assets, those benefits come into fruition.
I think last line of questioning I have is, I guess I struggle a little bit with some of the kind of summary statements. I don't think it's in your testimony, but in others' testimony, that this advances, you know, Kansas renewable energy goals. I guess the way I view our goals, or at least maybe this is my personal view, is that our goal is to access the most optimal, lowest cost energy and deliver that to customers. I wonder if this is a case of a company being frustrated that they can't access some of that, and so they're going to build it in a less optimal place. And so I wonder if in some ways that's against the interest or the stated goals of Kansas, and would invite any reaction you have to that statement. But I guess where I'm really going with this is, I mean, how would you evaluate the feasibility of an alternative of either building or accessing through a PPA a lower cost resource west of you, and then trying to deliver that to Empire? or having to deal with the, hedging your congestion to get the value of that. I would like to know your thought process of why that is or is not a feasible option for Empire right now.
I think it is an option. I just don't believe it to be the lowest cost option. And you brought up a really good point there, and I want to make sure that I keep everybody on board in this, because you said congestion, right? And congestion can get hairy in a hurry. And congestion is really just the difference between, to simply put it, let's take losses and everything else out of it. Congestion is just the difference between one node and a different node. And so what Commissioner French is discussing here is, if there's congestion, if you're getting paid lower cost for a generator in Western Kansas that may have come with a lower cost PPA, is there not an ability to hedge it to get it back to your load? And what I can say is my experience in the SPPIM, and I've been doing this since day one. I do have a wind farm out in kind of north central Kansas, so that would be my closest proxy. I have not been able to get a single LTCR, so a long-term congestion right, to do a universal kind of round-the-clock hedge. I have been very limited on getting any kind of TCR during any season at all. And in fact, to the extent that you do get a hedge, it generally means there's some kind of line out and you may have a congestion pattern flip on you a little bit. So your ability to hedge that is, in my opinion, has become very limited. And the fact that 2 of the 3 of our wind farms, I don't need to take a TCR hedge on. They're already in my load node. And yes, there may be, occasional line outages that create a slight basis differential. Altogether, I don't have to rely on a market product to try to get there, especially a market product that I've not had great success with getting, the further you get away from your load node, the more constraints that you actually have show up in that congestion hedging market.
So to put that in simpler terms, I won't say layman's terms, but would I be right to say, for the wind farm in north central, I think you said north central Kansas, that you have a PPA on, to the extent you can't get a congestion hedge on that, and you've indicated that's rare if you have.
Yeah.
The way that works is you just sell that energy into the market, and then to serve your load, you just have to acquire energy at whatever your local LMP is, which is a much higher price. It's, just to make sure I'm thinking of that correctly. And you don't have any triage between those two price points.
You're 100% correct. So just for round figures, like I said, this is imperative to keep everybody on board. If I sell power for $10 out at that proxy wind farm, and I'm buying from my load for $30, so my customers are paying $30, and then their offset is going to be the $10 power there, right? So that gives them a net $20 impact. If I can generate that same amount of power here, I'm basically down to zero, right? And so when we say what the TCR does is it says, okay, if you're generating at 10 and you're buying at 30, any kind of, I guess, volume of product that you have, you can take that $20 differential and flip it and start to protect yourself. So I hope this makes sense. It is I know it gets really hairy, and I'll try to do my best to continue to explain it to the extent we have any other questions. But yes, those products to hedge the difference between a wind farm that has a low LMP versus a load that has a high LMP has been very difficult to come by. And like I said, we actually do a really good job with our TCR portfolio. We've been able to cover our day ahead congestion costs in total. But that's because we have to take some additional positions elsewhere and basically make up for some of the congestion that we're paying somewhere else. So we feel like this is a risk mitigation, a risk hedge, and it will continue to provide lower costs for our customers.
So I guess what I'm trying to get at is you have a recommendation from staff that Empire should have just acquired or could have acquired a PPA at something like $1.50 or $15 per megawatt hour. But I think what you're saying is that's not really an option available to us, or not really feasible. because of the inability for me to ensure that I could get a congestion hedge and actually gain the value of that contract. So that's not an appropriate comparison. Am I going too far to say that that's what you're claiming? Or are you just saying there's risk that we wouldn't be able to get that value?
I would say, I mean, I can't say that if we built a wind farm out in Western Kansas, we could just magically get a perfect hedge that matches. I mean, your volume is never going to match. I can tell you my experience with the TCR market. Like I said, I've been doing this since day one. I took our very first positions and I've overseen it the whole way through. The likelihood of getting a TCR from something out in Western Kansas delivered to Southwest Missouri, which, remember, the TCR is the way that they determine feasibility. They do an injection and a withdrawal. And so the likelihood of us being able to obtain a decent TCR or a TCR at all, based on my experience and based on a proxy node that we have in our experience, where we try to get 100% of it if we can, is very, very unlikely.
Okay. I guess you've made me think of one more question. I apologize. I keep thinking of new ones. I'm just trying to weigh through, pros and cons of the different options. And it strikes me that, the pro of the $3.30 or $33 type of price where you are, I mean, if all things work out, that all just nets out because you sell it into the market and you buy it at the same price. There is more of an upside if you produce more than expected. There's more of a risk if you produce less than expected, because you're talking bigger dollars, right? If you come in lower, then you're going to have to go acquire it at $33. Is that a fair characterization?
I think what you're saying is there is risk. Yes, I think it's fair to say there's risk. There's risk in every one of these projects. Absolutely.
I think that gets me to where I need to be so far. I'd like to hear Cross, and I may have some additional questions at that time. I appreciate your answers, though.
Yep.
All right. Thank you, Commissioner French. Commissioner Duffy, cross-examination.
I'm going to wait to see how this goes. Thank you.
Okay, very well. Cross-examination, Curb. Mr. Lowe.
We do not have any questions for the gentleman.
All right, thank you. Cross-examination, the KCC staff.
Yes, staff does have some questions for Mr. Dole.
Please proceed.
Good morning, Mr. Dole.
Good morning. Good afternoon.
Mr. Dole, you mentioned in your example in response to questions from Commissioner French that an example of what you might be able to sell this wind into the SPPIM was between $25 and $30 per megawatt hour. Do you recall that statement?
Yes, I do. I think what I was saying was that's about what our load cost was, but I think that's a reasonable proxy currently for market prices in our area. Yeah.
Mr. Dahl, do you know what revenue per megawatt hour Empire estimated that this wind farm would be sold into the SPP marketplace during the first year of operation, and therefore what value would flow through the ECA?
I want to say, I'm trying to flip through a DR. I want to say it was somewhere in the $26 range.
From staff's understanding of the data that we have reviewed, would you accept that the revenue number in Empire's rate case was in the $22 per megawatt hour range?
For the 55 million, I'm looking at DR 12 from Andrea Jackson, the 55,294,000.
Yes.
I would suspect it's probably higher, depending on the capacity factor. But I think we can proceed as if it's in the ballpark. That's reasonable.
Okay, so you would accept the revenue number in Empire's rate case was in the $22 per megawatt hour range.
That's what was filed. Kind of where you get. That's what we filed.
Yep.
Sure. Without
Yes.
subject to check. Yeah, I can go back and it's reasonable.
Okay. Thank you, Mr. Dole. At this time, I do not have any further questions.
All right, very well. Let me double back here with the commissioners. Commissioner French, any further questions?
No, thank you.
Commissioner Duffy, any further questions?
Let me look here just a moment.
Certainly.
So let me go back to an earlier statement that was made by Mr. Rooney, that RFPs just did not need to be looked, PPAs did not need to be considered, just didn't need to be considered. So is that exactly your spin on this as well?
Not being a part of that particular process, I guess I would say the company believes that, as I think we've indicated here, that we felt like we could deliver the same benefits as a PPA. And so at that point, it was the belief that a competitively bid build own transfer project would still have the market competition factors embedded in it, but that we would have the benefits of what we've described earlier, the generation interconnection ownership, the repurpose of the Asbury facilities, the continued employment of some of the Asbury employees, so on and so forth.
Okay, so make sure I understand, you weren't part of the decision-making team when those decisions were made to go forward with RFPs. You were not part of that group?
I was not part of that group, but I do support the decision.
Okay. Mr. Chairman, that's all I have right now. Thank you, Mr. Dahl.
You're welcome.
All right, thank you, Commissioner Duffy. Mr. Dahl, I have no questions for you either. We'll turn it back to Mr. Flaherty. Do you have any redirect?
I do. I have a few questions. Thank you, Mr. Chairman. So, Mr. Dahl, going back to, I think, one of the first line of questions that Mr. French asked you, and you gave him a formula to try to explain how the net to the customers is, and you started off with the fuel cost plus the LMP minus the off-system sales. Do you recall that line of questioning?
Yeah, I would say fuel costs plus the purchase power, LMPs are everywhere, but purchase power minus the off-system sales revenue. Yeah.
Okay. And so for wind, you indicated that the fuel cost is zero because obviously there's no fuel cost to generate the energy from the wind project, right?
That is correct.
Okay. So if Kansas customers don't get the advantage of these three wind projects, and in other words, they'd have to rely upon some of your other generation that would have fuel cost, then that would have to be taken into account, correct?
To the extent they didn't have access to the low cost wind in their service territory, they're still paying the same LMPs, as you said, for their purchase power, and then their off system sales revenue would not reflect the revenues obtained from this wind farm. That is correct.
Right. And so and do you have if the fuel cost is based upon the company's ECA, do you know what that current ECA is?
I believe the ECA as of our latest filing is somewhere in the $22 to $23 range, subject to check.
Okay. And so the commission staff attorney asked you some questions to basically compare, I think, I guess the price that you're currently getting, which I think you either decided it was somewhere between $22 and $26. You recall that line of questioning?
From KCC staff?
Yes.
Yes.
Yeah, you had a discussion with them about what how we estimated the revenues for the wind farms. And then he had $22 and you had, I think you said $26, but somewhere in that range. Do you recall those questions?
That was the estimate of revenues, okay. Not what we've seen thus far.
What have you seen thus far? How's that compare to the estimates in the rate case?
Sure. So the easiest way for me to kind of give a feel for the revenue is, we've had these projects have been in different state of construction through 2021. North Fork Ridge was actually completed with a finalized purchase and sale agreement in January. So we have the most experience with North Fork Ridge, which is in the center. I'm also fully aware of Uri kind of really disrupts a data set when you're talking about the numbers. So I want to be fair to the data set and say, we don't typically expect $4,000 LMPs. I will say that the wind farms were all able, even in their various stages of construction during Uri, to generate, which offset some of the costs. And part of that is in part due to the cold weather package. But if we take North Fork Ridge and we do a February 2022 12-month ending, right? So I'm starting at the end of this February and backing up to March. So I've removed Uri from the data set. We're sitting on approximately $16.5 million of revenue from that wind farm. Okay. So how do we kind of extrapolate the $16.5 million from this wind farm that has full construction? The other two didn't have a PSA till May 5th, I believe it was. So I don't have a full data set with them. And I would say this is a little bit of a conservative number too, because we did have some grayback curtailments. Since then, we have got a permit which really reduced any kind of curtailments that we have. So 16.5 million represents roughly 25% of the total nameplate of all of our wind farms, right? So you take 16.5 million, you divide that by 0.25, and you're somewhere in the $66 million range, which ends up being higher than the 54. Now we know market prices have been a little bit higher as gas prices. So, we don't expect to hit just the precise numbers in IRPs year after year. But I think what we can show is that this first year, with the variables that we encountered and removing Uri, somewhere we estimated the dollars reasonably close. I would say the 54 million and the 66 would be considered reasonably close. We got higher this time. Perhaps next year it may be a little bit lower. I don't expect it to swing as much. But I'm only talking about market revenues here too. And so when you take the fact that we have 2 of the 3 wind farms in Missouri and 1 in Kansas, the renewable energy credits that we had forecasted in the case, I think is in data request 12 from the KCC, estimated REC revenue of about $467,000. Again, you can't precisely say exactly what REC revenue is going to be well out into the future. I can just tell you what the current market is, what we've seen over the last year. And we've seen the REC market sort of explode. We've been selling RECs for somewhere in the $4 range on average. We've made some strip sales up to $6, and we've made some other sales down in the $2.75 to $3 range. The Missouri wind farms do have a little bit higher value because some Missouri entities will want those to meet their RPSs. And so we've done some strip sales. So even to the extent you do have some slips on the LMP, to the extent the REC market holds, goes up a little bit, goes down a little bit, or gets closer to what you've seen in PJM or in Ohio, where you're seeing more $9 to $12 RECs, this is another benefit that is automatically passed through to the customers via the ECA. So it gives you kind of a buffer on any kind of slip on the LMP to the tune of, let's say $2 to $6 range. So we can call it just an average $4.
Okay. So let's go back to what the staff suggested to you is, let's say even if the LMP rate you're getting averages at $22 a megawatt hour, and you look at, well, it's costing you $33 a megawatt hour. Why can you say that the customers still get savings under that scenario?
Well, I don't want to lose anybody here. And so I think the easiest way to do that is just kind of benchmark it. To the extent we cover 100% of our capital costs, that is terrific. You're not going to get that with any other kind of generator, which is why wind is, on the price that it is, and it's the way it's proliferating the way that it is. But to benchmark, and I'll use only the available data that I have. When I look at Western Plains, and I certainly don't want to pick on it because I don't know enough about the following ECA, ACA filings. A lot of the information is redacted, but it's essentially a $21 PPA that has roughly $4.80 of LMPs. And so, there's a reduction down to about $15. It still has a net cost of $15, but, compared to the ECA and the avoided production cost that was described in that filing, it still showed a benefit. So let's take that same logic with ours. We have $33.75 PPA price or proxy PPA price. Right now the revenue is closer to $28, but let's call it $22, right? So you've got about $11 difference right there. And $11 is certainly lower than our $22 to $23 ECA. In fact, it pencils out a little bit better at that time. So, this kind of just goes back to, there is some increased capital costs to put the wind where we did, but it's generating substantial revenue, and it's while there could be some dips in LMPs in the future, I don't expect it to ever hit the range that it would hit out in Western Kansas. And so this is just becomes a very precise and perfect hedge for our customers. It is a great value for our customers in particular.
Okay. One of the questions that got deferred to you, and I don't know if it got asked, was about this cold weather package and whether your current PPAs have cold weather packages on them. Do they?
I think the question was about Uri, and I don't know enough to know if it was a cold weather package, precisely what the cold weather package, what the ambient conditions were. I'll just mainly speak just precisely to what we encountered during Uri. So we have 2 wind farms. One of them that was closer to us ended up getting curtailed to 0, basically froze up on the 9th of February, and it had a return to service date of the 22nd. And like I said, I can't say precisely what package it had on it to say, what caused that. But it juxtaposing to units that were near it. The Neosho Ridge unit is very near it. It was, even though it was in a stage of construction, it was generating. North Fork Ridge was generating. Kings Point was early on in construction and was generating. So comparatively, they performed well. Meridian Way out in Western Kansas had some derates during kind of the height of the storm, but it was still able to generate some megawatts.
Okay. So, and I guess this goes out without saying, but just for the record, that if you have a wind farm and it has the cold weather package, that's gonna increase the cost of wind farms that compared to those wind farms that don't have that cold weather package, right?
Yes, the cost to put on that package would be higher than to not have that package. That is correct.
Okay. Commissioner French asked you some questions, and in response to those questions, you talked about, I guess, the benefits of having interconnect or generator interconnect. Would you have those benefits if you don't own the GI because you have a PPA instead of owning the wind farms?
My experience with the PPA is you take the power on the high side, you don't have the generation interconnection, so you don't have those potential benefits.
Okay. Finally, Commissioner French asked you about, I guess, the risk that is involved, I guess, with the revenues associated with these wind farms. Do you recall those questions? And I think you indicated there was some risk. Is there a way, in your opinion, that the commission could address those risks?
Yeah, I think there's opportunities to try to collectively come to an agreement that addresses the risk. Like I said, all these investments have risk, just to varying degrees. A lower cost PPA with substantially lower wind revenues, has less, we'll call it LMP risk. But we do have basis risk and other things there. If we're to take a low cost LMP for us. We talked about TCR risk, congestion risk, deliverability risk. And so I think there's a way to collaboratively find a way to hedge that risk and ensure that the benefits that we projected, the benefits that we're already seeing, and then some, make sure that the customers don't take the full force of that risk.
So is there a way to share the risk between the customer and the utility? How would you do that if there is? How would you do that?
I think there's a lot of opportunities to find ways to share risk. I think there's a way to ensure that your LMP revenue hits, certain metrics. There's a way to share LMP revenue. I think it's just a construct that has to be jointly developed to make sure that, like we said, we know that prices don't hit a precise mark every single year and stair step up, but over the longer term, they do tend to follow, the forecasts to the extent you have a good forecast. And so, to the extent you can develop some sort of risk sharing to make sure that the benefits that were promised to customers are delivered, I think that's something the company has interest in.
Thanks. That's all I have, Mr. Chairman. Thank you, Mr. Dole.
Thank you. Commissioner French?
Yeah, a quick follow-up, because I think Mr. Dole may have cracked the code for me. Finally got my head wrapped around a concept here. I've clearly been struggling with how to put this investment decision in the context of other options that were out there. And you walked through some math with Mr. Flaherty, and I just want to confirm that I'm thinking of this the way that you're asking us to think of it. I understand other parties may have a different position, which we'll hear about, but I think you talked about the value proposition in terms of netting out the revenue after, I guess you did the math of 3375 of sort of the levelized cost of energy associated with these wind farms, and then subtracting potential revenue at $22, coming up with an $11 net energy cost, production cost, essentially, or an ECA type of number. And then comparing that $11 net figure to a hypothetical Western Plains wind farm, not knowing all the details, but assuming that their levelized cost of energy was around $21, and you subtract $4 revenue, that they would have a $17 net production cost. So comparing, in your example, that $11 net cost of energy for Empire's customers would be substantially better than the $17 net cost of energy for the Evergy customers. Obviously not dealing with exact figures there, but am I understanding that that is the example you're giving, and that is the comparison that you're trying to make?
That was the example I was trying to compare. Like I said, I have, the data that I have on that, and I'm certainly just trying to create a benchmark. Because I think what got missed was, low cost PPA, great $4.80 LMP is not so good, right? Higher cost PPA, but average $26, $28 power. We feel like even with the dip in the LMPs, we're still going to be right side up on this for sure. Yes.
That we've certainly got that in the record now that we have your testimony. Do you know whether that particular description or example is laid out in anyone's testimony? I don't recall seeing it that clearly laid out, but is there? I know there is discussion of differences in revenue opportunities, but I don't know if that particular type of example is laid out somewhere.
I don't know if it's precisely laid out the way that I did it, but I think there is maybe a proxy comparison, maybe in Mr. McMahon's rebuttal.
That's what I was. That's, I think, the closest I've seen. Okay.
Okay.
Oh, I appreciate it. That helps me. Like I said, I'm sure others will have different views, but I wanted to make sure I was understanding the comparison that we were making there. So
Sure.
Appreciate that. That's all I have.
Thank you, Commissioner French. Any further commissioner questions? Seeing none, Mr. Dahl, I believe we've reached the end of your testimony. We thank you for your testimony. You may virtually stand down and you're excused. Thank you.
Thanks for the time.
Well, let's regroup here in view of the availability of witnesses and the kind of the timing and sequencing of events. We definitely, Mr. Love, are going to have time to take up Ms. Crane's testimony next. What I would propose that we do, we've been going here for a little over an hour. The time is not really bunched up on us yet, and in the interest of our court reporter and I think the rest of us, why don't we take a 10-minute break and return at 2:30. We'll stand at recess until 2:30, at which time we will take up Ms. Crane's testimony. We're off the record. Michelle, are you there? Or Denise?
Yep, you're ready again.
Okay, very good. Looks like we're reforming here. Thank you. Naola, are you ready to go?
Yes.
All right.
Chair King,
Yes.
KCC staff would just like to renew one of our earlier
Yeah,
requests.
I'll take care of it straight away.
Okay.
Trust me. Okay. This time. All right. Let's go back on the record. It's about 2:31 p.m. on March 8th. We are back on the record. Let's take care of a few housekeeping matters first. I think the KCC staff had requested that we change the order of witnesses so that their witnesses could all appear last. It appears to me that with where we've come and what we have ahead of us, and I want the council to express a different view if you have it. It appears to me that if we begin tomorrow morning, first of all, I'm sorry, we'll handle the testimony of Ms. Crane next. Then when we resume in the morning at 9 o'clock, we will take up the testimony of Mr. McMahon, followed by Mr. Mooney and Mr. Tillman. That will take care of all of the Empire witnesses. Then we will honor the staff's request that the staff testimony go last. After Mr. Tillman, we will take up the testimony of Colin Kane and Nicholas Puga, followed by the testimony of Justin Grady. That would be the game plan I would set out there for tomorrow. And I believe we can conclude this by tomorrow evening, hopefully, so that we have this wrapped up in 2 days. That's the game plan. Do any council have any reservations, objections, concerns, or other ideas about that? All right, hearing none, that will be the game plan that we will pursue. At this time, I would ask you, Mr. Love, if you would please call your witness.
I would call Andrea Crane and ask that she be sworn in, please.
Do you solemnly swear the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Good afternoon, Andrea. Can you hear me?
I can, Todd. Can you hear me?
Yes, I can hear you just fine. Thank you.
Great.
Okay. Could you please state your name and business address for the record?
Yes, my name is Andrea C. Crane. My business address is 2805 East Oakland Park Boulevard, Suite 401, Fort Lauderdale, Florida.
And by whom and in what capacity are you employed?
I'm president of the Columbia Group.
Are you the same Andrea Crane that caused to be filed 34 pages of pre-filed direct testimony dated January 13th, 2022, and 10 pages of testimony in support of the unanimous partial settlement agreement on March 7th, 2022?
Yes.
Do you have any changes that you'd like to make to your testimony?
No, I don't.
If I were to ask you the same questions today, would your answers be the same or substantially similar?
Yes, they would.
Commission, at this point, I'd move that the pre-filed direct testimony in support of the unanimous partial settlement agreement and the direct testimony of Ms. Crane be admitted and spread upon the record, and would tender the witness for cross-examination.
Is there any objection? Without objection, the pre-filed testimony is admitted. Very well. Good afternoon, Andrea. Nice to see you again.
Good afternoon.
I'll again begin with commissioner questions if they wish to do this. I'll start this time with Commissioner French.
Morning, Ms. Crane, or afternoon, sorry. I think I just want to ask you maybe one question and then would reserve anything else till after cross. Did you hear the sort of the final exchange I had with Mr. Dole regarding sort of how they view the value proposition to customers here, and how they might benchmark or try to compare the value proposition of their wind farms versus something like the Western Plains wind farm. At a high level, I think they make the assertion that the value to customers is actually greater. There would actually be more ECA savings under their scenario, based on the revenue opportunities that are available. And I wanted to give you an opportunity to, I guess, give me any thoughts you have on that comparison of whether you think it's fair, whether it doesn't recognize certain things like risk to ratepayers. Is it a feasible way to look at this situation? I would like your reaction to that, because it is, I'm trying to put this in context of how I should think of the overall value to Empire's customers.
Okay, sure. Yeah, I did hear that. And I do have a couple of thoughts. I mean, first of all, basically, they indicated that the spread between the revenues and the expenses, essentially the net amount that needs to be covered, is perhaps more favorable in this particular situation than it is in the Western Plains wind farm. And to be honest, I don't recall the details of the Western Plains wind farm, but just looking at that formula kind of on a standalone basis, I mean, regardless of how large that spread is, there is a spread that needs to be recovered. Now, the company has indicated in its recent testimony that much, perhaps all of that, might be covered by fuel savings. And so there would then be a net benefit to ratepayers. I think we have to keep a couple of things in mind. The first thing we have to keep in mind is that the fuel savings aren't the only factor here. We also likely have the generation facilities that were that went with that was using that fuel. Those generation facilities presumably are still in rate base and therefore in base rates. So customers who may in fact receive the benefit of the revenues, and they may receive the benefit from the fuel savings. But on the flip side of that, not only are they paying the capital cost of the new wind, they're also paying the capital cost of that initial generation facility. So that's something to keep in mind. The other thing I think that's important to keep in mind is that let's assume that there is a tremendous benefit or potential here for savings when you look at the revenues and you look at the fuel savings. Those savings could also have been realized through a PPA. I mean, those same savings could have occurred if the company had gone out and entered into a PPA instead of purchasing or instead of incurring the capital cost to build its own generation. And so I think they're ignoring the fact that the real problem here is that they didn't make that an option. They never gave the ratepayers the option of having a PPA. They admit, or I think staff did a beautiful job this morning showing how the facilities weren't needed for generation and capacity. And I think the company has pretty much admitted that, although there's been some backpedaling. But number two is, let's assume that there were some real financial benefits of swapping out that generation. It could have been potentially, we don't know this, but potentially it could have been swapped out at a much lower cost. And it wasn't. Why wasn't it? In my view, it wasn't because it's to the company's benefit to have that investment on its books and have its shareholders earning those dollars. Now, the company says, well, wait a minute. We kind of looked at this and we decided that we could do it just as efficiently as a third party. And we will never know whether that's true or not, because in fact, they didn't go out and solicit a PPA. There's been a lot of criticism of looking up PPA prices over that time frame on Google, for example. Well, the fact of the matter is staff and CURB had to rely upon public information because the company failed to solicit a PPA when it decided that it was going to to bring on new generation. If they had done that in the first place, we wouldn't be here today having to Google what PPA prices were in the 2018 timeframe. We would know because they had actually gone out and done that work. They haven't. So I guess that's a long answer, a long way of saying, yes, I think the revenues are helpful. I disagree totally with the company's assertion that we didn't consider those revenues or the staff didn't consider those revenues. I think both of us considered those revenues. And when you have to step back and look at this entire package and say, does this make sense based on the reason that it was being built, the reason it was that they decided to own it rather than to enter into a PPA and all the other factors. And I agree with staff that the answer to that is no, does not make sense.
So let me play devil's advocate very quickly. You made a comment that the exact same benefit was available through a PPA. The way I'm understanding this math is that you've got a cost of $33.75, but you've got modeled. Now we may not. Who knows if we all agree on what the modeled revenues are? But revenues of $22, and so you've got a net of somewhere around what would it be, $11 or $12 of production cost compared to current ECA of $22 or $23. But I guess just looking at that $11 production cost, I mean, do you really think that there would be a PPA out there available to them at the $11 level?
Well, I don't think they have to get a PPA at the $11 level. I think all they have to do is get a PPA under $33.73. I mean, if their PPA was, and the Western
but they
Plains,
can't sell if they just have a PPA. They aren't going to be able to generate revenue off that, correct?
I think they would be able to generate revenue off of that.
Okay.
I mean, as long as they're getting incremental, they're getting incremental energy, and they're putting that out there and selling it is basically what they're saying here, right? Now, where that energy comes from, I don't see any reason why it couldn't have come from a PPA, and you have exactly the same situation from the financial angle. You have exactly the same situation with their example. Let's say instead of $33.73, let's say they had to pay more than Western Plains. No one is saying, I don't think that the Western Plains price is the absolute price that you should use. Let's say they had to pay $25. Okay. And let's say they sell it for $22. Okay. Well, now you have a much lower spread that you have to meet than $11. So now I will agree with the company that there may have been other benefits to ownership that they couldn't have gotten through a PPA. For example, they've talked about control, and I admit, that does provide some benefits. What happens after a 20-year period? In this event, they will still own that facility. That could provide some incremental benefit. It also, in my view, creates a lot of incremental risk that they wouldn't have with the PPA. But I do admit there is also some incremental benefit there. But in terms of just looking at that revenue versus costs versus fuel savings impact, I think there would have been the same potential with a PPA. Is
it fair to say that your biggest problem at this point with what they've done is it isn't necessarily the financial impact or the financial projection? It's the fact that we don't have a PPA within the RFP process to benchmark this off of?
I think that is a major issue in this case, that we don't have that. That they, right from the beginning, went out, bought land, entered into other land lease agreements. I mean, there was never any real consideration for a PPA. That is a problem. But I think the numbers are also problematic. The 3373 does seem high certainly relative to PPAs that were out there at the time that they were acquiring this generation. I think there's a tremendous amount of risk with regard to revenues. There was testimony this morning with regard to the Asbury capital improvements. Why did you make like, what was it, $120 million, I think, something like that, capital improvement in Asbury, if you were going to shut it down in 4 or 5 years. And I think the response was market conditions can change dramatically. And in the case of Asbury, they did change dramatically. And that's why we're left with this huge stranded cost for Asbury, which we've dealt with in the settlement agreement. However, I would caution you against putting too much stock in 20 years of revenues when, admittedly, I think none of us really know for sure what's going to happen next week. So I guess that's all I have to say about that one.
Thank you, Ms. Crane. That's all I have for now. I'll reserve any further questioning until following cross. Thank you.
Welcome.
Cross-examination, Commissioner Duffy.
Thank you, Chair Keen. Good afternoon, Ms. Crane.
Good afternoon.
So if you could focus a little bit, I guess my understanding is, what is the real need for this power that's coming from these wind farms? I mean, it basically, and I can't get my hand on whose graph it was, but it shows, one, that Asbury was losing. I mean, they were below 50% in terms of their efficacy to Empire's energy source. Also, the IRP shows that going out to 2038, the need for additional generation is flat. So it's my understanding that this wind power is more than just what Asbury was producing in terms of megawatt energy. So it kind of gets back to, is this just viewed as a proposed cash cow, or do you believe they have plans to offset their other types of energy, their combustion cycle and some of their other plants? Is that the grand scheme here that would seem to make this work?
Well, personally, I think the motivation here, and it's not unique to Empire, is how much investment can we make and get approved and get reflected in rate base so that we can increase our earnings. We know that that's likely not going to be easy to get approved by the commission. So let's take a look at projects that we also perhaps can demonstrate some potential benefit to ratepayers. And that's exactly what's been done here, in my view. And again, this is not unique to Empire.
Is this kind of the MO that others are following, that build CapEx and put those costs into your IRP to ensure that shareholders do receive an increased return?
Absolutely. You can go to just about any public utilities presentation to analysts, all of which are public. And you probably look at these yourselves all the time. If not, I invite you to Google again. It's amazing what you can find. All of these presentations are public, or many of them are public. And usually on the first slide, the word investment will appear, and you'll be able to see that this is the way that utilities are attempting to increase shareholder earnings. I mean, that's just a fact, and it's pretty much universal at this point. They do have essentially flat sales, so it's not like it might have been 10 years ago or so when these companies were growing 3 to 4 to 5% a year in terms of their usage. That's not happening anymore, and so they have to look for some way in order to grow earnings. And the only way you do that is you either increase the rate of return or you increase the investment, or both. And that's pretty much all it is. And I do think that the companies are hopeful that there will be a net reduction in cost to ratepayers if revenues are high enough. But that certainly is by no means assured. What is assured, though, as I think staff indicated, is that shareholders will at least have the opportunity to earn a profit on these. Ratepayers may or may not be better off, but these certainly were not needed for capacity or energy or to meet an RPS requirement.
Okay, thank you. And I'll hold any further questions.
A couple of questions from me, Ms. Crane. Were you online when we examined Mr. Rooney and cross-examined him?
I was.
You may recall in my cross-examination, I asked Mr. Rooney why the company did not take into consideration the opportunity costs of not pursuing or pursuing a PPA approach in lieu of this cost ownership approach. So on the other side of that very question, I would ask you, why would they not? Why would you not consider the opportunity costs of the most likely alternatives versus the one that you're inclined to really prefer?
I think because they were afraid that maybe they wouldn't get the answer that they wanted. I mean, and I think by opportunity costs, and perhaps I'm misunderstanding you, but I think what you're saying is, why didn't you go out and solicit a PPA, or why didn't you consider the cost to you, the company, of not having gone out and soliciting that PPA? I mean, if they had done that, we wouldn't be here, right? Probably wouldn't be here arguing this. I think the reason is, at least based on the data that we've been able to acquire over what prices, PPA prices were during that time frame, is because they felt that they were going to get a result that they didn't want, and they potentially thought that they were going to end up with PPA prices that were lower than what they were looking for. Although it was interesting this morning because I believe it was Mr. Rooney. I think CURB counsel asked somebody, and I think it was him, about the, were you familiar generally with PPA prices at the time that you made your decisions to acquire this new generation? And I thought the answer to that was no, which I found very surprising. But certainly someone at Empire or at Liberty or at Algonquin was surely familiar with PPA prices in the SPP during that time frame. Admittedly, there are differences between various, regions and placements, but overall, I think that when you look at those prices, they're pretty astonishing. I mean, we're not even close to $33.
Thank you for your response. In part, in answer to the question that you somewhat rhetorically asked of me in trying to determine what it was I was actually asking, what I was asking is really quite simple. It's just basic opportunity cost methodology. I'm simply asking, why didn't the company, in a formal way, assess the cost and benefits of the most likely foregone alternatives? That's really all I was really asking. If we could turn to your pre-filed testimony for just a moment, please, on page 7.
Yes.
I should note for the record here that when we beginning on page 6, there is a summary of your conclusions and recommendations regarding the requested revenue increase. What I want to look at particularly there, if I could, Andrea, are your conclusions number 6 and number 7. This is page 7 of your pre-filed testimony, lines 4 through 9. Take a look at that for me for a minute, if you would.
Yes.
Taken together there, can you just summarize what is your conclusion here, and how did you go about reaching these conclusions in particular?
Okay. My conclusion in number 6 is that basically, if you decide that these wind projects are appropriate to charge to ratepayers, you don't do it through the traditional rate-based rate of return approach, by that, I mean, you don't put the entire amount in rate base in year one and then depreciate over, some long depreciable life as you would normally in a rate case. Therefore, I'm recommending more of this levelized cost of energy approach, similar to the approach that was used in the Western Plains wind farm, which will basically spread out a levelized cost over the life of these facilities, or some life. It doesn't have to be the entire useful life, some life of these facilities to ratepayers. Assuming you want to approve these and you want to do it then on a levelized cost basis, the big question is at what price? And that's really where the rubber meets the road, because they're at $33.73. Staff is down significantly lower than that. I'm going to try and avoid numbers because I think something still might be confidential, although I know there's been a lot of things have the company has removed the confidentiality on a lot of the numbers. My recommendation in this testimony, and this is a number that is public now, by the way, my testimony doesn't indicate that, but this is a public number now, is the 2397. And that is the number that was used in the generation fleet savings analysis. It also happens to be relatively close to the Western Plains wind farm. It happens to be slightly above the range of PPA prices that were indicated from the Lawrence Berkeley National Lab survey. And for all of those reasons, I felt that for me, who perhaps didn't do as in-depth a study as staff's witnesses did, but for me, that I felt was an appropriate target or benchmark for the commission to consider. It also happens to be relatively close to the $22 or so revenue estimate that the company itself reflected in its filing. So I think when you looked at all those numbers together, that was the number that I decided to focus on. And especially since it's the company's number. Now, I understand there's been discussion, well, we changed the formula. If you went back and you used our new formula, and when we did the generation fleet savings analysis, you'd now be up closer to the $30 range. But the fact of the matter is that that was the number, not only that was, I suppose, presented to the Missouri Commission, but also is actually still contained in the company's testimony in this case. By several witnesses. So I put all that together and I had to make, admittedly, a somewhat subjective recommendation. And I think 2397 is the number that sort of all of those things converge on.
Well, thank you for embellishing those conclusions. I was looking for a bit more, and you've provided that. I appreciate that very much. Let me turn next to Mr. Flaherty for cross-examination.
Thank you, Mr. Chairman. I think I just have one follow-up question to Commissioner Duffy's question to Ms. Crane, and I think you were discussing the nameplates on Asbury and the 3 wind farms, and 3 wind farms are 600 megawatts and Asbury is 120 megawatts. But you would agree that these wind farms don't, even though their nameplate is 600 megawatts, they don't get that credit for that full nameplate because the wind always isn't blowing, correct?
I do agree with that, but I think also Commissioner Duffy's point was that Asbury wasn't operating to hit its full nameplate capacity either. I think my recollection is that she had some concerns about the fact that Asbury was not performing well in the past few years, as indicated by Empire's testimony. So I would agree that none of those facilities generate up to their nameplate capacities.
That's all I have. Thank you.
Thank you, sir. Mr. Jevons, on behalf of the KCC staff, cross-examination.
KCC staff does not have any questions for Ms. Kane.
All right. Any further commissioner questions of Ms. Crane? Yes, please, Commissioner French.
I appreciated your dialogue, Ms. Crane, with Commissioner Chair Keen, and on your recommendation of the $23.97 figure. You know, just kind of looking at it subjectively myself, that seems like a more in the ballpark type of number of what you would expect to see, maybe in a little higher cost area for a wind PPA. And so I guess I'm kind of sharing your subjective view on that. But then as I read the testimony, there was a lot of testimony that said, oh, these are completely different formulas. You could never use it for that purpose, which I struggled with a little bit, because I thought that was the number that was used to justify this plan in the Missouri proceeding. One, am I thinking about that right? Was that your view of what this number was used for? And two, is your mind at all changed by the sort of the technical discussion that that number is derived from a formula that could never be used to set rates? Any reaction to that?
Sure. I believe that there was actually, at least in one of the Missouri proceedings, the number was 2380. I think we talked about that a little bit this morning. There was a slight difference, but very close. Now, I don't know all of the backup material that the Missouri Commission also might have had available to it and reviewed when it made its decision. I wasn't involved in that process, but certainly the 2380 was one of the numbers that was reviewed. And the generation fleet savings analysis was certainly a primary document in that case. And when you go through the generation fleet savings analysis, they talk about more like the $23, $24 number. I didn't see anything, close to 33.73 in there. They're my thoughts. And I actually, I think, again, no one is saying that is the number. I did look at the rebuttal testimony about the differences, differences in location, differences, potentially in technology and all sorts of other differences. I'm not an engineer, so I can't definitively, offer you an opinion about those engineering aspects, but there's a pretty big difference between, 23 and 33. If somebody said, well, yeah, for reasons X, Y, and Z, that would add a couple of dollars, that could add a couple of dollars. I'd say, yeah, maybe that's reasonable, but we're talking $10 here. That's almost 50% increase. And so I just didn't feel that moving above that 2397 number, which had been presented by the company, was a reasonable avenue to take. And I haven't really seen any real hard quantitative data from the company either about what would move that mark. So I think when you put this into all the evidence together, I think that you have to conclude that if you're going to allow ratepayers to pay for this, at least at this time, you should be focused more on a number that's more like 2397, the $20.70 from the Western Plains Wind Farm, more like $22 of the revenues, in that range, in that ballpark. Now, staff had an interesting comment this morning when in its presentation, I believe they made a comment like, maybe we'll reevaluate this in a couple of years. We don't know what's going to happen in a couple of years. They may need capacity, or whenever they need capacity, if those wind facilities are still operating, then perhaps the parties can get together at that time and say, all right, now we all agree we need the capacity. Does it make sense to take another look at those facilities? But As of right now, I would say absolutely not. And my opinion has not changed based on the rebuttal testimony that was filed in this case.
Thank you. One follow-up question, and this is going to be me playing devil's advocate again. If something like $24 was your proposed number for a PPA type of simulation, and we assumed that their revenue was going to be $22, seems to me that almost means customers are going to be getting energy almost for free. That the ECA associated with this energy is going to be, I don't know, a half a cent or less. To me, that's probably not reasonable. Is that a reason to think that the $24 is not reasonable?
No, I think one of the things that you should look at is what could they get a PPA for now? And, I'm not sure that there's information about that in the record. There may be, I just don't recall. But certainly they could have gotten, it appears they could have gotten a price well below that in the 2017, 2018 timeframe. They may be able to get that price or even a lower price today. And staff's witness may have had something in their testimony about more recent PPA prices. Now that I'm thinking about it, they may have gone up, had some information about through 2021. And furthermore, if the company really feels, if it really does feel that it needs capacity today, maybe it ought to go out and issue an RFP today to see what's out there and what options are available and where those proposals come in. So again, I mean, they didn't solicit the PPA. So we don't really know. But if customers could have gotten a PPA at $20 when this generation was built, if they could get something, in the low 20s today, there's no reason, I don't think, for the commission to approve a rate of $33.73. And if ratepayers benefit somehow because revenues are much higher than anticipated, well, that's good for them. There's a lot of pressure on ratepayers, so I'm too troubled if ratepayers end up with a good deal occasionally. But I think this is a fair deal at a price of $23.97.
All right, thank you. That's all I have. Thank you.
All right, thank you. Any further commissioner questions? Very well.
You real quick.
Oh.
So their PPAs are expiring. So if they'd gone to the companies and said, hey, we're expiring, we can renegotiate or else I can build my own. Typically, what would those companies do? I mean, is it so easy to say, oh, well, never mind, goodbye. Got a company waiting in the background here, they'll snap it up.
Right. The company today, I believe I heard testimony today that they had gone to those companies and discussed renegotiation or extension of the contracts. And I thought I heard the only thing that those two were willing to do was to extend the terms of the contracts and increase the price. We didn't hear about any specific price, but I think I heard that from those particular facilities. We don't know why they would make those decisions, come to those conclusions. We don't know what other options might be out there today. So but the company said that they did approach them and that those two said no. But, you know, that's only 2 out of the universe of wind developments.
Okay. So can we talk about another area, the decommissioning of the plant? So I believe in your testimony, I mean, that's left for another day. But do you have any other comments you would like to share related to the decommissioning?
No, except I was happy to hear what I thought I heard in cross-examination, that the cost estimates have come down. I think that's obviously a positive. I would just say that it's my understanding that while we are supportive of a regulatory asset as requested by the company for those actual decommissioning costs, and we're supportive of examining that regulatory asset in the first rate case after decommissioning is completed, we are not really taking any position on cost recovery until we see, you know, what those costs are and what was done. So I think that all parties still have the ability to make whatever arguments they want in a future case with regard to prudence and reasonableness of those costs and ultimately cost recovery. But given the uncertainty and frankly, given the importance of decommissioning and doing it right, we felt that it was appropriate to allow the company to record a regulatory asset.
Okay. Thank you very much. I appreciate your comment on that. That's all I have, Mr. Chair.
All right. Thank you, Commissioner Duffy. Any further redirect?
No, sir.
All right. Very well. Ms. Crane, we thank you for your testimony. Appreciate it very much. Your testimony is concluded for today. You may virtually stand down and you are excused. Thanks again.
Thank you very much. Thank you.
Well, I believe in terms of the availability of witnesses, we have reached the end of our road for today. We will go ahead and recess. Our intention, as we've just explained it earlier, is to reconvene tomorrow at 9 o'clock. And our first witness up will be the Empire witness, James McMahon. I think that's it for the day. We stand in recess. Thank you all. Be careful.
Thank you.